Commissioner Marita is present and participating remotely. Commissioner Kevin Morrison is absent. Commissioner Sean Morrison.
Present.
Commissioner Scott.
Present.
Commissioner Scott is present and participating remotely. Commissioner Stamps. Commissioner Stamps is absent. Commissioner Trevor. Commissioner Trevor is here. Commissioner Vasquez. Commissioner Vasquez is present. Chairman is present. Chairman, let me revisit those that did not respond. We have absent Commissioner Degnan. Commissioner Degnan is present. Thank you, ma'am. Commissioner Gaynor, absent. Commissioner McCaskill is now present. Thank you. Commissioner Kevin Morrison is absent. Commissioner Stamps is absent. Chairman, you do have a quorum. I'm going to remind the commissioners to please use your mics when speaking so that your voice is caught on the audio. Thank you.
Now I know that we have a few members that are remote. Can we take a roll call for remote participation? Lead for roll call.
Mover and seconder, sir.
Burton, Commissioner Lowry.
Commissioner Aguilar, your vote, sir?
Aye.
Commissioner Aguilar is aye. Commissioner Naya? Aye. Commissioner Naya is aye. Commissioner Britton?
Aye.
Commissioner Britton is aye. Commissioner Daly? Commissioner Daly is aye. Commissioner Degnan? Aye. Commissioner Degnan is aye. Commissioner Gaynor is absent. Commissioner Laurie?
Laurie's aye.
Commissioner Laurie is aye. Commissioner McCaskill? Commissioner McCaskill is aye. Commissioner Miller?
Miller, aye.
Commissioner Miller is aye. Commissioner Marita?
Morita, aye.
Commissioner Marita is aye. Commissioner Kevin Morrison is absent. Commissioner Sean Morrison?
Aye.
Commissioner Sean Morrison is aye. Commissioner Scott?
Aye.
Commissioner Scott is aye. Commissioner Stamps is absent. Commissioner Trevor?
Trevor, aye.
Commissioner Trevor is aye. Commissioner Vasquez? Commissioner Vasquez is aye. Chairman, your vote?
Aye.
Chairman's vote is aye. Chairman, you have 14 ayes. 3 absent votes for Commissioner Gaynor, Commissioner Kevin Morrison, and Commissioner Stamps.
Madam Secretary, are there any public speakers for this meeting?
Yes, Chairman, we do have a list of public speakers. I need to read a statement, but as I'm reading, I'm going to ask Police Chief Mitchell Davis and Police Chief Sean Staples to come to the mic. Those authorized to provide public testimony shall be allotted 3 minutes in order to do so. You will be reminded when you have 1 minute remaining, 30 seconds remains, and when time has expired. Authorized speakers are expected to complete their statements within that time period. You will not use vulgar, abusive, or any other profane language when doing so. I will remind you when your time has expired. You may begin.
Good morning, Commissioner Moore, Commissioners of the Cook County Criminal Justice Committee. I am Chief Mitchell Davis from the Hazel Crest Police Department. I'm here today to speak in support of Resolution 25-1695, which calls for a hearing of the Criminal Justice Committee to review an update from the public safety county stakeholders on the implementation of safeguards for the protection of gender-based violence survivors and domestic relations, mediations, and child representation. I would like to thank Commissioner Donna Miller for sponsoring this resolution. In addition to being Chief of Police in the village of Hazel Crest, I currently serve as a board member for an organization in the Southland called ANEW, Building Beyond Violence and Abuse, which provides long-term resources and advocacy for women and their children that are fleeing abusive relationships. ANEW also provides offender resources in an effort to help curtail recidivism. Recently, ANEW was forced to cut 3 victim advocacy positions due to funding constraints. I also serve as a commissioner on the Illinois Commission on Discrimination and Hate Crimes. With the rise in hate crimes of all types, the commission is focusing on prevention of violence of all types, including gender-based violence, through education. In addition to the new Illinois Help Stop Hate hotline, we are conducting webinars that are accessible statewide to combat violence and hate. I also traveled to South Africa with the Attorney General's Alliance, a bipartisan group of attorney generals from around the country that come together to collaborate. In Cape Town, South Africa, I was honored to speak on a panel with the district attorney from the Bronx, New York, on the subject of gender-based violence and other efforts to address these crimes here in the United States. Gender-based violence and domestic violence are pervasive worldwide. One of the most common tools that is used in combating domestic violence is the order of protection. In Illinois, domestic violence order of protection is most often issued by a judge after a domestic violence incident results in an arrest. After the arrest, domestic violence advocates, such as those with ANEW, walk victims step by step through the process of obtaining an order of protection. With victims already having been traumatized by their offender and being unfamiliar with the courtroom procedures, advocates are essential in helping victims get through the process and getting their paperwork before a judge. If an offender is not arrested, a domestic violence order of protection can still be obtained. Victims are provided with reports and documentation from the police department and are able to bring the paperwork to the state's attorney's office. Advocates in the state's attorney's office are then able to assist victims in navigating the process of getting before a judge to obtain an order of protection. I close by reminding everyone that orders of protection are not the end-all to domestic violence, but they are an essential tool, when used properly, to help combat and minimize continued domestic abuse and hold those accountable who seek to perpetrate that violence against others. Thank you for your time.
Thank you, Chief.
Thank you, Chief. Police Chief Sean Staples, are you here? If not, the following individuals, not connected. State Rep Hernandez, followed by Carmen, Navaro, Gerconi.
Madam Secretary, would you please add me to the roll?
Yes, ma'am, we will. State Rep Hernandez, Carmen Gerconi. How about Sarah Brown, Diane Brown? Come on, thank you.
Traffic jam in the aisle.
Thank you.
I
You may
apologize.
begin.
Good morning. I'm here to express my support for Resolution 25-1695. I would like to thank Commissioner Donna Miller for sponsoring this resolution. My name is Carmen Navaro Draone, and I have over 30 years of experience in law enforcement and criminal justice. My professional background includes service with the Cook County Sheriff's Office and the Clerk of the Circuit Court's Office, in addition to collaborations with the Chicago Police Department, Illinois Attorney General's Office, State's Attorney's Office, and the Office of the Chief Judge, where I was twice appointed to the Domestic Violence Committee. I also serve as an immediate past president for the FBI National Academy Northern Illinois Division Board and participate as a Community Advisory Board member for the University of Illinois Cancer Center, and I'm currently working with both the National Sheriff's Association and Johns Hopkins School of Public Safety on the national implementation of extreme risk protective orders. I am committed to addressing the underlying causes of violence and crime, with a particular emphasis on issues related to domestic violence. Exposure to violence within the home can have significant and enduring impacts on children, particularly when those responsible for their protection are the perpetrators. Despite some progress, governmental responses often remain inadequate, compelling families to continue advocating for increased funding, emergency housing, advocacy, resources, services, and protections. Today, you may hear perspectives that are unexpected. Our objective is to highlight the risks inherent in a fragmented system. In recent months, we have spoken with over a dozen victims who share children with their abusers and have faced challenging choices between pursuing orders of protection, securing child support, or seeking a divorce. While victims may request protective orders during domestic relations proceedings, access to domestic violence advocates and relevant resources is often extremely limited or unavailable. Moreover, court personnel, including guardians ad litem, child representatives, attorneys, and sometimes even judges, frequently lack adequate training on domestic violence matters, which has led to the re-victimization of several survivors. A couple here today were even incarcerated. Having worked extensively within the system, I urge all involved to uphold accountability,
1 minute.
practice transparency, and demonstrate the courage necessary to identify and improve areas in need of reform. Let us collaborate to ask, what more can we do? And listen carefully to those affected. For instance, ensure a complete and accurate record of all court proceedings using a court reporter. This would provide judges with dependable information, reducing reliance on recollection alone. Require all professionals working in domestic relations courts to undergo
30
comprehensive
seconds.
domestic violence training. Consider the cost and fees associated with certain mandated processes. Protective orders, child support, custody, and visitation should always be prioritized over court fees and fines. Thank you.
Our next speaker, I called a couple of names. Come on up and tell us your name. Are you Sarah?
Yes,
Thank
Sarah
you.
Brown.
You may begin.
Good morning. My name is Sarah Brown. I stand before you today not just as a survivor of domestic violence, but also a mother who shares a child with my abuser. I am here to speak in support of Resolution 251695, which calls for a hearing today. I want to extend my heartfelt thanks to Commissioner Donna Miller for sponsoring this resolution and bringing us together to address the pressing issues. It has been approximately 7 years, 3 months, 70,000 hours since I first started my court process. In that time, I have faced the daunting challenges of navigating a system that often feels like it's more concerned with policies than with people. I've encountered 5 judges, 2 guardians ad litem, one of whom was disqualified. I have witnessed my 8-year-old son being victimized by his father, who continues to have access to him despite the history of violence and abuse that hangs over us like a dark cloud. On Thanksgiving Day, November 2024, I had to witness my son being present while his father battered his then girlfriend. This is not just a story of my struggle, it is heartbreaking reality for many families. I have made countless pleas, to train professionals, showing them previous restraining orders filed against my abuser, only to see his parenting time increased in February 2024 instead of decreased. This system needs to change. I am calling for all complete overhaul of GAL and Child Representative Committee that is responsible for appointing lawyers to act on behalf of our children within Cook County. We need a system that prioritizes the safety and well-being of children, not one that perpetuates the cycle of violence. Furthermore, I request that judges within the domestic relations divisions have real oversight and monitoring of the appointments they make. We cannot afford to allow our children to fall through the cracks of a broken system any longer. The lack of resources for victims who share children with their abusers is alarming. In the Southland alone, at the Markham and Bridgeview courthouses, support is virtually non-existent.
1 minute.
This is disgraceful reality that misleads many organizations that claim to advocate for us, victims, while being funded by Cook County. We deserve better. Our children deserve better. I reserve the rest of my time.
Please announce yourself.
Diane Brown.
Thank you. Please begin.
Good morning. My name is Elder Diane Brown, the founder and executive director of Giving a Helping Hand Outreach. For over 20 years, our organization has been dedicated to empowering families and children throughout Illinois. With an effort on the Southland communities of Cook County, today I stand before you to speak in support of Resolution 251695. I would like to take a moment to thank Commissioner Donna Miller for sponsoring this crucial resolution. As we gather here today, it is important to recognize the alarming statistics surrounding domestic violence and its impact on children. The number of children present during domestic crimes in Chicago increased by 35% from 2020 to 2021, rising approximately 8,200 to 11,000. This rise in exposure of domestic violence is devastating. Over 90% of individuals seeking help for domestic violence have children. This underscores the urgent need for adequate services and resources to assist these families. Giving a helping hand, our mission is to bridge the gap in services for families affected by domestic violence. Currently, there is no designated parental responsibility exchange or supervision alternative in the Southland region, aside from local police stations where our children should not have to face additional trauma. We provide critical services aimed at reconnecting families and minimizing further trauma. My personal passion for advocating on behalf of families and children affected by domestic violence stems from my own experience with my youngest grandchild, who has tragically faced the shortcomings of the Cook County system. The experience has fueled my commitment to ensuring that no other family endures such hardship without the right support. After 44 attempts to trying to communicate with Chief Judge Evans, as a retired CPS mandated reporter,
1 minute.
it was disheartening to witness and endure witnessing my daughter, Sarah Brown, being treated by Judge Bernadette Barrett to be locked up for attorney fees by an attorney she appointed pro bono. I being removed from courtroom for wearing a mask. However, I felt it was due to my courtroom monitoring by Judge Maritza Martinez. I now yield my time. Thank you.
Chairman, our next speakers are Maria Michard, Arlena Criley, Alexis Maravas. Or if you're in the room, please come to the podium. Maria, followed by Alina, followed by Alexis. And state your name before you begin, please.
Good afternoon, everyone. My name is Alena Criley, and I will speak about Marissa Martinez. I'm a mother to a soon-to-be 6-year-old child, James Criley, that I love dearly. I did not see him from December 13, 2020. And I'm here to ask who will remedy the lost motherhood? Who will remedy the child? The child has rights as well. So there are laws everywhere, right? We are in civilized society. We are supposed to be. And I believe so too. And obviously, English is not my first language, but I did my work and I studied the rules. And I found out there are rules. There are plenty on the shelves. And I'm calling here for accountability of judges, first of all. They run the show. They run the show of GALs and attorneys. And Illinois Supreme Court requires them to report attorneys' misconduct, and Illinois Supreme Court requires attorneys to report judicial misconduct. It's not happening. The show continues. Illinois Supreme Court rule requires, number 922, requires child custody cases to be resolved within 18 months. My case started in October 2020, almost 5 years. Almost 4 years, I have not seen in person my son. My order of protection was dismissed for want of prosecution, while Judge Maritza Martinez, Cook County Calendar 97, she did not let me in Zoom. She gave an order of protection to my abuser. So in Cook County, it's an alarming situation. It's not just mine, but it is alarming that abuse is fostered. It's profitable. It's profitable to continue cases for 5 years, to appoint a private guardian ad litem, and then to issue pay to see your kid orders. It took me an appeal to get evidentiary hearing in 4 years from start of the case. It was already order of protection. It was tables turned around, order of protection against me, and I couldn't get evidentiary hearing for 4 years. It's like, I'm asking, how is it happening? It's happening because of lack of oversight by Judge Evans. And I did attempt to speak to the Chief Judge's office.
30 seconds.
And what we are told, go file complaint to Judicial Board of Review. Illinois Supreme Court Rule 21 requires Chief Judge to take action. It requires the power given to him. He does nothing. Moreover, presiding judge office, presiding judge domestic relationship office, staff attorney tells us
Arlene?
that it is
Alina,
few seconds.
Your time has expired, but if you could please wrap up your statement.
Yes,
Thank you.
thank you. They tell us that somehow it's ex parte communication about cases when we report judicial misconduct. So we are turned around. There is nothing done. That must be stopped. I have a lot more to say, but I'm asking everyone present, I need to see my son. I need to raise my son, and the child needs mother. We do not want next generation to be traumatized by Cook County Court and their childhood to be stolen and women's motherhood to be stolen. Thank you.
Thank you for that. Next, please, tell us your name.
Alexis Maravas. Good morning, and thank you to the board for taking the time to listen. This is an incredibly important topic, and I'm grateful for the opportunities to speak. My name is Alexis Maravas. I'm a United States Marine Corps veteran, a former patrol officer with the Tinley Park Police Department, and now a domestic violence advocate with Metropolitan Family Services. But I'm also a survivor of domestic violence who shares a child with my abuser. I filed for divorce from my abuser in 2021 with years of physical violence, including being punched in the face, getting a black eye, being dragged by my hair, and being strangled approximately 12 times while pregnant and in front of our child. The most severe incident occurred on March 1st, 2020, when I was strangled in front of our son, who was 1 year old at the time. My ex-husband was arrested for aggravated domestic battery in Cook County because his actions clearly met the elements of that felony crime. Despite this, I was still forced into mediation with him during our divorce process. When I expressed concerns about being on a Zoom call with my abuser, the mediator told me I was making things difficult and even suggested I think of the good times in our relationship. That kind of dismissal made me feel unheard and unsafe. A guardian ad litem, Mr. Roberto Madera, was later assigned to our case and unfortunately added harm. During a Zoom call with my young son, who was 3 or 4 at the time, my son was understandably shy and quiet. He had never used Zoom before and didn't know Mr. Madera. After the call, Mr. Madera called my son slow and developmentally delayed, which was completely untrue and beyond his qualifications to state such. My son has met every developmental milestone according to his doctors and teachers. He was simply behaving age appropriately in a strange situation. Mr. Madera repeatedly showed bias in favor of my abuser. He falsely claimed I taught my son to call his grandfather dad to imply parental alienation. He also said directly to me and my attorney that the charges against my ex were trumped up, even though I, as a police officer, had to remind him that strangulation during a domestic battery qualifies under Illinois law as a felony crime. These comments were not only offensive, they were dangerous. My divorce, overseen by Judge Iman, lasted more than 3.5 years and cost me over $30,000. Our son is now 7 years old. I will be forced to return to court to revisit parenting time until he is 18 years old. I will have to relive this trauma all over again just to keep my child safe. This system re-victimized me and endangered my child at every turn. Today, I urge the board to support the following reforms. Mandatory training on domestic violence, including post-separation abuse for all family court professionals. Prohibit forced mediation when there is documented domestic violence. Create clear accountability for guardian ad litems, especially when they display bias or cause harm. And most importantly, stop prioritizing an abuser's parental rights over a child's safety. No child should have to be injured or worse just to satisfy
30 seconds.
the court order of parenting time with a violent parent. Survivors and children deserve protection, not punishment. I speak today not just for myself, but for the countless others suffering in silence. Thank you for listening.
Thank you. Our next speaker, Melissa Oldridge, followed by Clinton Washington, Kenton Gerard. Are any of you in the room? Please come to the mic, please. Even if you're out of order, just tell us your name. Melissa, Clinton Washington, Kenton Gerard.
Good morning, I'm Clinton Washington. I'm here to talk about the corruption in the Domestic Relation and Domestic Violence Department at the Daly Center and the play-to-pay scheme. In 2010, I was granted custody of my daughter in DuPage County due to the mother being abusive, neglectful to my child. The case was transferred to the Daly Center in 2011. From 2011 to 2022, I have been in domestic relations court. And I have endured injustice, extortion, and even incarceration due to a system that supports the person who abuses the child. During the time at Cook County, the judge coerced with my child's mother to be deceptive, to be contemptuous, and to show bad faith. The judge appointed a child rep by the name of Matthew Kirsch to oversee the best interests of the child, but ultimately he was only concerned with his monetary gain. Over 10 years, I have paid over $250,000 towards child rep fees. When I could no longer pay the child rep fees, I was incarcerated. I was incarcerated for not paying a child rep, not for any child support or anything like that. This was the first time ever in history this had been done in Cook County. I was incarcerated during the height of the COVID infection. I was incarcerated for 6 months. During that time, I caught COVID 4 times and was not released. Judges were releasing hardened criminals due to the overcrowdedness of the jail and the spread of the COVID. But my judge, Judge Maritza Martinez, please remember that name, Judge Maritza Martinez. She would not release me. The judge joked, laughed, taunted me during my time in jail. This is a broken system that needs to be fixed. All the money I paid, she wrote on her court orders it had to be cash bonds. I could not pay cashier's check. I had to pay cash bond, meaning bringing cash in the courtroom to pay the child rep. Thousands of dollars. I lost my house. I filed for bankruptcy. Basically, she took everything I had, and I paid over $250,000 towards child rep fees, over $500,000 towards attorney fees, which I had to hire attorneys so I can eventually get out of jail.
30 seconds.
I was here before speaking before I was incarcerated. I talked to Tony Preckwinkle. I talked to Judge Chief Evans. No one did anything. FBI, no one did anything. No one did anything. So I'm here again for the second time speaking up on this topic. And now there are more victims. I was the first victim ever. Now I see more victims. So I'm asking that someone, anyone, please put a stop to this judge. Her name is Judge Maritza Martinez, and she is very aggressive, and she has extorted me along with the child rep for a decade. Okay, I'm done.
Thank you. Next on our list, Kenton Gerard. I have a name of CITA, C-I-T-A, Dr. Latoya Glass, Andres Rock. Are any of you in the room? Let me know that you are before we move to the other speakers. Thank you. And state your name when you come to the mic, please.
Good morning, everyone. My name is Dr. Latoya Glass. I'm Carmen. I'm here today in stance of the domestic relationships that's going on in our court system today. I filed for divorce in August of 2020. Next month, we'll make 5 years, and we still reside in a house together. I act as the presiding president of a chiropractic business in Country Club Hills called Miracles Revealed Chiropractic Wellness Center, Incorporated. In 2023, Judge William Boyd ordered a business valuation to be done on the chiropractic business, but denied an evaluation of my husband's business, Aspire Painting and Drywall, which has been operating since our marriage in 2007. He ordered that my personal income be analyzed, but not my husband's, which has been estimated over 6 figures a year. He also ordered that the chiropractic business be solely responsible for all the fees pertaining to this valuation. He appointed Attorney Jennifer Fletcher to do the evaluation. After 2 years, with me willingly submitting the information that was asked of the business to the best of my ability and having to do so on multiple occasions, even being asked to send it again, and almost $5,000 in fees. The process of the evaluation, and I'll quote from attorney Jennifer Fletcher, is nowhere near completion. I filed for a motion for financial assistance from my husband toward the business valuation, for him also to respond to why he had not complied to the judge's order 3 times, to contribute to the household, and also to contribute to the expenses of our 3 kids, which is 12, 14, and 16. We had a hearing on June 13th of this year. My husband's motion was first heard, which they asked me to respond why I no longer wanted to continue with the business valuation. Immediately after that hearing,
1 minute.
In closing arguments with no warning, no opportunity given, that was previously given to my husband when he disobeyed the judge's court order 3 consecutive times and was allowed to make payment even after he lied under oath about his finances, Judge Boyd held me in contempt for violating the court order from 2023, sent me to the Cook County Correctional Facility, and ordered me to pay $21,200 to get out of jail.
30 seconds.
And I had to pay the full amount to get out. I was devastated. I went numb. Since then, depression. Because I became a victim of a system that I thought operated out of faithfulness, fairness, justice, accountability, and good character. But my story proved to be the complete opposite. And to add injury to insult, that same court order that I was locked up in was later found to be was found to show that my husband's business is responsible for all fees returning pertaining to the business valuation. Thank you.
Thank you, doctor. Next person, please state your name.
Hello, my name is Andres Roque. I'm here because I want to speak on the name of my twin sister, Maria Roque. She passed away in December of 2023. She was killed by her abuser in front of her kids. She did multiple. She went to the police department multiple times, and she filed an order of protection. And even though with that order of protection, she still went to the police officer because he was still calling her, texting her, telling her that his excuse was want to see the kids when it was just want to know that she was home. And every time he would call a police office just to do to check his daughter, it was just to see that if someone was home. So he would do like he did on her birthday. He burned her car. And the police said, oh, we just got to file this. And they knew that he was in the order of protection. He was still going by the house. Even the police would tell him, like, oh, you can't stay. But when she finally had the chance to, go to the main court and file a police, against him for arrest, the next day he killed her. So I feel like the papers is not protecting, not even, I just feel like I'm here is just because I want to, there's so many abuse that seeing my sister and seeing my niece and nephew and those, I feel like the police and that order of protection should be more than just a paper. I think it should be if you know that person has kids, she's not only fighting for herself, she's fighting for her kids. And he was like a horrible guy, and and it's so many things that I want to say about it, but I just feel like the system failed her, and it's not the first time and she couldn't be here alive still if the system and the police would have had arrested him earlier when he tried to attempt to go and see her. So I just feel like this is just I feel like they should protect more domestic violence. Should be a criminal,
30 seconds.
They should add it more as, sorry, I'm really nervous, but I just feel like this should be more like not failing at her. And now that I'm still here, I could fight for her, even though she's not here. And I'm doing it for her kids, and I'm doing for my family, and because we do miss her. And the name of Maria Roque will always be, and I want everybody to know that she fight. And I hope this will help, others to fight for that, because we need to protect people with domestic violence. Thank you.
Thank you. Kimberly Black? Kimberly Black. After Kimberly will be Katie Dunn.
Good morning. My name is Kimberly Black. I want to thank Commissioner Miller for this bill, 251695. My heart goes out to everybody who's spoken already. I have been a victim of domestic violence. Unfortunately, the way the system is set up presently, it has a lot of flaws. It's very helpful also, but it does have a lot of flaws. I have gone to 555 West Harrison. I did not feel protected when I was there. It was very scary. It was very difficult to navigate. Getting an order of protection is great. However, the police treat it like it's just a piece of paper. You and your children don't get the protection that is required, because when you're walking towards 555 West Harrison, you're just not protected. You're walking up there by yourself, scared to death, looking back and forth to see if your abuser knows the court date that you're going for. Leaving the courthouse, you're afraid because you don't know if somebody's standing out there watching you. You don't know if they've gotten somebody else to stand out there and watch you. My ex-husband has driven past my house because my restraining order said that you can't be within 100 feet. Well, if you drive past my house, you're within the 100 feet. If you decide to shoot up my home, the bullet will travel that 100 feet and you can be killed. Just saying, oh, it's okay, it's not okay. It's very scary. Going into all of unknown territory, in a state of mind that is something that you can't even imagine. The fear level is enormous. The paranoia is even higher. And working with small children, my children were 7 and 9, you have to protect them, you have to keep them safe, you have to hold their hand, you have to look both ways. You have to think ahead of anything that could possibly happen to you. My ex-husband finally got charged with harassment by electronic device, which is great, but at the same time, what does that really do? It doesn't protect me from getting crazy phone calls in the middle of the night. It doesn't get me protection. It doesn't get
30 seconds.
Thank you. It doesn't get me not in a state of safety. And as we heard earlier, women are getting killed because when you call the police and say, I have an order of protection, they said, well, that's just a piece of paper. Not only that, I was not allowed to renew my restraining order after a certain amount of time. They said, oh, it's been years. That doesn't matter. It doesn't matter if it's been 100 years. I don't want him near me, and I don't want him near my children. And that's kind of the point of it doesn't run out. The threat is still there, and the threat will always still be there. And I need the court to understand. I need the police to understand. I would like something done so that when such a thing happens, people say, oh, we're on our way. We're coming to help you. And it doesn't seem to be what's happening at this point. And I thank you.
Thank you. I want to remind our speakers that you have 3 minutes in order to address the body. I'm going to call the last 7. Katie Dunn, followed by Matteline Bear, Annette Milville, Jason Weinkoop, Alessa, I'm sorry, you're going to have to tell me your name. I can't read this. And then Richard Shine. So please announce your name.
Hi. Good morning, Commissioners. My name is Katie Dunn. It's a pleasure to be here with you today. There's a little change. I was supposed to be giving a presentation, so I'm going to try and get through as much information as possible in a quick amount of time. I want to thank Commissioner Miller and all of the other advocates here today, and then especially the really brave survivors that we've been working with over the course of the last few months. As you've heard today, their mothers, fathers, nurses, police officers, business owners, immigrants, lawyers, and doctors, all of whom have helped us throughout this process. We will circulate the information afterwards, so I'm just going to go through what would have been slides. We're here today to talk about the intersect between domestic violence and domestic relations court. It's something that's long overlooked because civil court just is in Cook County and always has been. In Cook County, domestic relations court is a primary point of contact with victims and their children, but very limited resources are available. The system is lacking any competency in terms of working with victims of violence, and the current policies and practices are increasingly putting victims and their children in danger. Just to kind of review some of the recent data, we've made tremendous success from so many of you and also our Cook County State's Attorney on reducing violent crime. However, domestic-related homicides are up 34.6%, and domestic-related murders with a firearm are up 81.8% in 2024 over 2023, which was a record-breaking year. In domestic relations court, there was 41,795 cases versus 11,200 cases in domestic violence criminal court. Per capita in 2023, the city of Chicago had a higher domestic murder rate than New York and LA County combined. Domestic violence is a crisis here, and domestic relations court is a major issue that many women have gone through and their children are currently stuck in without receiving services and without any oversight or competency. When domestic violence becomes endemic, it is dangerous for the entire community. Just yesterday, the state's attorney was able to bring justice to the family of Officer Andres Vasquez Lasso from CPD, who was killed responding to a domestic violence call. We've seen hospitals, we've seen schools, and we've seen workplaces also impacted by the violence. Some of the key findings from our discussion is the lack of transparency, which is also a Cook County issue that I would love to talk to you all more about. Unlike domestic violence court reporters and recording services are not readily available at hearings, hindering accountability in court processes. Legislation or remote access policies are obstructing the ability for stakeholders to communicate, to analyze the system, to share data, and to protect victims. Orders of protection are civil court records, which is very misunderstood, which means that you have to have access to the civil court record management system to see these cases. Very few stakeholders have access. That includes our law enforcement partners, which means that this hinders if there is a missing woman, if there is a murder case. Oftentimes they do not know that there was an order of protection filed. If orders go unserved, they remain non-public documents, meaning they're not public record. That serves no one except for the system that's failing women. If victim misses court, their court is vacated and impounded, which means it never existed in terms of case record management. One victim knew that her abuser had 5 orders of protection from different women, but could not prove it in domestic relations court in their custody case.
1 minute.
Putting her son in grave danger. There's a complete lack of services. When you go to domestic violence court, there's an amazing group of advocates there. They do not cross over to domestic relations court. So just to explain this really important, critical, key issue. If you walk into domestic violence court and you file an order of protection, if you have any child support case, any divorce case, any custody case, your order of protection gets assigned to domestic relations and all services get cut off. There's very little transparency. There's very little data available on the Cook County court systems, especially the civil court system. But anecdotally, if you are reading these horrific high crime stories of murders and children being killed, oftentimes they started in domestic relations court. In addition to the attorney's fees and all of the fees that we've been talking about, as Clinton shared, he spent $250,000. There's no transparency about how these lists are generated.
30 seconds, Chairman.
So guardian ad litem is supposed to be an advocate. A child rep is supposed to be their lawyer, yet they have no competency, and they have no background. They have no mental health background, and they have absolutely no domestic violence training. That needs to change immediately, and that is something that the commissioners can do.
Chairman of Criminal Justice, I have the authority to be able to extend your time.
Oh, thank you.
Traditionally not done, but with leave of the body, then your time 2 more minutes.
Thank you, Commissioner. Well, I'll slow down, so I apologize for the rush before. In a survey of litigants in domestic violence court, many of whom are here today and many more with pending cases did not feel comfortable speaking publicly, 90% shared that they felt they were in danger and they were worried about the safety and well-being of their children. The average case length was 4 years, but most just go on until the children age out. Some had cases gone for 10 years, 15 years, 16 years. That's a lot of out-of-pocket costs, and even just coming down here and paying for parking, as many people know, is a huge expense. Some of the other key findings was 100% of the participants shared that fees and costs were a top concern. Court fees are not dischargeable by bankruptcy, so we drive people into bankruptcy and then we don't let them become free of these charges. The debt remains. In a survey, many of our victims reported to have spent over $50,000. As I said, these are nurses, these are mothers. A lot of people are on have social services available for food and for other income, yet we're charging them $500 an hour for lawyers. Incarceration and threats. Threatening to incarcerate or remove custody of children was reported in 82% of the cases during our qualitative study. And as you heard today, judges are incarcerating those who cannot pay their attorney's fees. As someone who worked for over 10 years on the criminal justice reform side with so many of you, that is daunting, and that needs to change. We worked tirelessly to get people out of jail who should not have been in there on a $100 bond. As Mr. Washington and Dr. Glass spoke of today, they were charged cash bonds after a bond has been eliminated in Cook County through the work of so many in this room. Lack of domestic violence, competency, and training. All professionals, including the judges, should receive training in domestic violence. A domestic violence advocate receives 40 hours of training, many of whom are volunteers. Yet the people that are paid in our system very well, either through lawyers' fees or by the county, do not receive much training at all. If they do receive training, it's not translating into the courtrooms. Mediation is being required in cases where the abuser sits on the other side and re-traumatizes the victim. That creates a power imbalance, and that would never stand in criminal court. The GAL and representatives, as mentioned, are all attorneys. This is a system that needs much more clinical and support elsewhere. Some of the key recommendations, and these recommendations came from our committee. There needs to be a survivor-centered committee to provide input and to assist with the selection and the approval process for these GALs, for these child reps, and for the 4 clinicians, I believe, that are approved to do child mental health evaluations, which cost $10,000 per evaluation. We need to conduct a systemic analysis on the court systems. All aspects of our court systems need to be analyzed through a domestic violence lens. Improve transparency, mandated court reporting, free record access, and to provide a data dashboard similar to what the City of Chicago does on the Violence Reduction Dashboard, which has helped also improve community services. Community services and domestic violence advocates have no access to any data in Cook County. So it's very limiting when you're trying to apply for grants and other funding opportunities. We have stagnant amount of domestic violence beds in the city of Chicago. There's no data on how many are available in Cook County, but it is drastically limited. We need to abolish the fines and fees and threats of incarceration. This is inflicting psychological harm and needs to be discontinued. And more resources, legal aid, advocates, housing, mental health are desperately needed. As mentioned, I worked for years on the criminal justice side. I worked in mental health court, and I'm personally impacted by mental illness. I have never worked with a group that is more traumatized than the group that we have been working with over the course of these months. This truly needs to end. We are here and ready to speak with all of you privately. We have much more information that we'll be sharing. Appreciate this time and opportunity, and thank you again to Commissioner Miller for being such an incredible advocate, and some other great advocates in the room, including Alderman Tabaris, who's been working behind the scenes with us as well on the city side. So I appreciate you all, and if anyone has any questions, I don't know if that's allowed, but I'm happy to answer.
Do it after the meeting. Thank you.
Thank you, Commissioner.
Please state your name so that we'll be able to tell how many remain.
Good morning. Hi, everyone. My name is Matteline Bear. Thank you for the opportunity to speak today. I'm the Deputy Director of Policy and Systems Advocacy for the Network Advocating Against Domestic Violence. We are a membership-based nonprofit made up of more than 40 gender-based violence direct service providers in the Cook County area, many of whom are here today. I'm speaking in support of Resolution 25-1695, calling for a hearing of the Criminal Justice Committee to receive an update from Public Safety County stakeholders on the county's response to gender-based violence. I would like to thank Commissioner Donna Miller for sponsoring this resolution, and for Commissioners Anaya, Degnan, Gaynor, Moore, and Britton for co-sponsoring. Our member organizations provide legal aid and advocacy services to domestic violence survivors, both inside and outside of court. We provide housing and shelter options, offer mental health support through counseling, and much more. There continues to be an increase to the Illinois Domestic Violence Hotline from Cook County residents. Last year, the hotline received 30,000 contacts from Cook County, which is a 22% increase from 2023. To meet this increase in need, our community of service providers needs continued investment from county officials. This includes a holistic investment for services inside the courtroom, like funding legal aid and legal advocacy services for survivors seeking an order of protection, or increased staffing in the domestic violence division. This also includes needs outside of the legal system, like cash assistance, counseling, funding for shelter and housing, as domestic violence is often the reason women and children become unhoused. Shelter is consistently the top need for survivors who call the hotline each year. We would also like to see continued investment and work on recommendations from the county's Domestic Violence Division Committee from 2022 on how the county can improve its response to domestic violence survivors coming to seek an order of protection at the 555 West Harrison and suburban courthouses. While some of these recommendations have been implemented, there continues to be more work on staffing, data access and transparency, and more that we hope to continue collaborating on. Thank you for the opportunity to provide testimony, and we hope to continue to engage in this discussion about how Cook County can continue and enhance its support for domestic violence survivors and their families. Thank you.
Thank you. And tell me your name again.
Matteline Bear.
Thank you.
Thank you.
And it is Annette next. Thank you.
Good morning. My name is Annette Milville. I'm the Director of Policy and Strategic Initiatives for the Chicago Children's Advocacy Center. I'm speaking in support of Resolution 25-1695, and I would like to thank Commissioner Donna Miller for sponsoring this resolution. Chicago Children's Advocacy Center is the only nonprofit in the city of Chicago that works on cases where children have alleged they've been sexually abused, age 17 and under. We are the nonprofit agency which coordinates those cases, and we are located in the Illinois Medical District with our partners, the Chicago Police Department, DCFS, and the Cook County State's Attorney's Office. We provide essential services on these cases, including intake services, advocacy, forensic interviewing, mental health treatment, and child life, and we also refer for medical exams. We have been doing this work for 25 years. We have been doing the work of coordinating investigations. And during that time, in our experience, as well as the experience of everyone you've heard already testifying this morning, children are affected by domestic violence as well as sexual abuse, and many times there is overlap. Based on our experience and based with our conversations with service providers, we have created an initiative. That initiative is entitled Can Hope, or the Chicago Advocacy Network for Hope. This agency is a multi-agency center which is based on the Family Justice Center model, which already exists around the country. Many states have a Family Justice Center model, which enhances collaboration among law enforcement, justice system, and domestic violence advocacy centers. There is only one Family Justice Center in the state of Illinois, and that is located in Rockford. It is time that Chicago has a multi-agency center or Family Justice Center. Can Hope is going to start and open their doors this fall in the west side of Chicago at Homan and Van Buren. We are partnering with other partners so survivors can go to just one place, complete a centralized intake process, and then meet with countless partners to meet their needs. This is evidence-based practice, the best community-based intervention for domestic violence, and it will help survivors navigate the multiple systems they need to engage with, including the court system and the criminal justice system. This process has been funded by the Office Against Violence Against Women since October 2021, and we have mobilized around 40 local domestic violence and sexual violence agencies and community members to develop this program. These agencies include WINGS, The Network, Mujeres Latinas in Acción, Sarah's Inn, Sinai Chicago.
30 seconds.
Additionally, we have MDT partners who are involved in this process, including the City of Chicago, the Chicago Police Department, the Cook County State's Attorney's Office, the Cook County Sheriff's Office, and the Cook County Court, and DFSS. We are opening the center this fall, and we are excited to provide this service to our survivors. We are building on the 25 years of experience in our collaborative approach to prevention, response, and intervention. We are excited to bring this proven model to Chicago, and we look forward to serving survivors of domestic violence. I'm also happy to take any questions later on about Can Hope and its process. Thank you.
Thank you. Our next speaker, please state your name.
My name is Olesia Jerima.
Thank you.
So first I want to thank everyone who came here and give us an opportunity to speak. It's very important for us, victims of domestic violence, to be heard. So I'm in the Cook County Court in litigation for about 5 years. My case 2020 D6449. I'm not afraid to say it. My judge is Julie B. Amen. And I'm here, want to use the opportunity to call for everyone to actually check the job, what the judges are doing, because there is too much discretion is given to them. And we have so many problems, so many victims of abuse are not capable to stand up for themselves and for their children. So as for me, my judge, Julie Ament, right now is put me in the process where I'm being extorted. I have to pay GL every month when I'm unemployed. I'm receiving food stamps. There is administrative order 2023D here in Cook County, which is nobody is following. People come to apply for a court fee waiver. No clerk ever heard saying, you're going to have a hearing today, you're going to get your court fee waiver today. Never happened. My judge has been delaying for months my court fee waiver when I'm receiving food stamps, demanding from me my W-2s, my tax returns, all my bank statements for years. She's still withholding it. My judge, Julie B. Amen. And there are other people here on the list who have the same judge and suffering from this. This is arbitrariness. I'm sorry. Maybe it's not pleasant to hear, but this is true. Then orders, my judge enters the orders, which are agreed orders, which I don't have consent. I don't have even the knowledge. I find out about it when I come to the Delhi Center. Then there are stamped orders, signed orders circulating, which are not on the docket. again, it's a mess what is going on. I have been trying to contact Judge Ganuccia many times, Timothy Evans, many times, many emails, no answer, nothing. Or if there is an answer, it's some nonsense like expert testing. I apologize. I might be a little using not very diplomatic terms, but it's just, it's when you're in this for such a long time, it is very difficult. Then whatever, last time we came to Judge Ganuccia's office, we were followed out by sheriff when we just asked to speak to someone. So nobody came out to us, nobody talked to us. When there is a Supreme Court Rule 21 where Timothy Emmons and Judge Ganuccia, they have to control the judicial conduct of the judges and they have to report it, it is not happening. We are just being ignored, dismissed. And for us, for some people as immigrants, when we come here to America, America is famous for its justice. Where it is, it's not here, it's not present, we cannot see it. Then I want to talk about also the GL situation. So I had the GL on the case, and instead of helping my child, he completely favorited my abuser, my ex-husband, falsified the report. The GLs here is a big, big problem because they are not protecting the best interest of the child at all. My son, after so-called help and participation of GL, 5 years, he made such a poor investigation, 5 years, first 5 years of my son's life, he never spent 2 days without me. He comes in on the case, he forces 10 days with the father, to be 10 days without mother. My child comes back, he's 5 years old. He is 10 now, 5 years of litigation. This has such a traumatic effect on him. He does not sleep nights. Child, 5 years. Many times, he's so
Alyssa,
traumatized.
Your time has expired.
Okay,
Please wrap up your
thank you.
statement.
Thank you. So I want to say, and I want to ask everyone here, if you have children, you know what is abuse. There is no super hard education needed to understand and to see and to recognize the victim of abuse. It's not a rocket science. So I'm asking of you, as a human being, everyone here, please pay attention to this matter and do whatever possible to have more oversight and accountability of judges who are making this decision, because we are having all these problems here, because the job is not done well. We have all these situations, all these issues, all these agencies, all this, why people are coming there.
Thank you,
because
ma'am.
there is no proper job done.
Alyssa, we've got to move to the next
thank
speaker.
you. I'm sorry. Thank you so much. I
Thank you.
apologize for a little
Thank
bit
you.
maybe rude or something. Sorry.
Thank you. Jason Wincoop is next, followed by Richard Shine. Jason, are you in the room? If not, Mr. Richard Shine.
Good morning, Commissioners, State's Attorneys. I just have a question. I hear this about the system being broken, and it is broken. How is it a man can be abused, but a woman can go into your system and file an order of protection the next day, and now you're the victim? You go to court, the judge say, okay, well, I understand what your problem is. But why is it that no one listens to the black man or the brown man? When are we going to start listening to us? I'm not down in the women, but what about the men? We are domestic violence too. When are you going to listen to our voices? There's so many of us in jail today because you don't listen to us. Why? Kids, men are in prison today because nobody listened to them. I came here today to activate on my behalf and the men that's in prison. When are you guys going to start listening to us? A woman could go in there and file an order of protection even though a man was abused, and she could get an order of protection. He could have his guns taken away. Police officer, law enforcement. Now he's got to fight 6 months to get his weapons back to keep his job. That's not right. The system is broken. Please, you guys sit here, make these rules, but who are you making the rules for? So maybe we need to start advocating for the men. I'm not downing the women, but what about the men too? You got men out here today that's being abused every damn day. Why are we not being listened to? All my friends are in prison now because the woman picked up the phone and said her husband slapped her. He's doing 2 years. That's not right. I asked the state's attorney, when are you guys going to listen to us? I went to the state's attorney's office and I asked them to listen to me. Oh, well, you know what? It's your word against her word. If that person was dead today, me was dead today, who would you listen to?
Thank you. Our last speaker did not respond. Jason, are you in the room? Jason Wincoop? If not, Chairman, I believe last speaker is going to be State Rep Hernandez. They asked me to call her again. State Rep Hernandez? Not? Okay, thank you. Chairman, I am under the impression that that concludes the list of speakers.
Well, there's 3, and we can just call them all at the same time. Let's not disrupt, and why don't we wait till they're post notice, and I'll call all 3 at the same time? Yeah. Yeah.
Madam Secretary, Commissioner McCaskill will move to approve the minutes 25-33-61.
So moved. Who's the seconder, sir?
Seconded by Commissioner Scott Britton.
Thank you.
All those in favor of approving the minutes, please say aye.
Aye.
Opposed? Motion carries. Now I'd like to call on Commissioner Donna Miller for opening remarks. I'd like to move approval of item 25-1695, moved by Commissioner Donna Miller.
So moved.
Seconded by Commissioner Alma.
Thank you, Chairman. I want to thank all the speakers, all the public speakers that we had here this morning for being so courageous and brave to come and testify in an open public statement to share your personal stories with us. As leaders here in Cook County, we're bound by our moral obligation to safeguard victims of domestic violence and related domestic violence, and particularly the children who we've heard so many stories about today, from recurring harm or in the most tragic instances from losing their lives. And as a mother, we can all understand that our first job is to take care of our children. So thank you to all the mothers who spoke about how you're working hard every day to make sure your children's best interests are heard and protected, along with your own stories of survival, that you have to navigate a dual process to make sure that you can get through every single day. We owe it to our survivors and their families and future generations to establish that our legal framework and processes that works to uphold equity and ensure safety and deliver justice, all at the same time and all together, not separate. So let us collectively commit to implementing the necessary reforms to safeguard our most vulnerable from potential harm. I am heartbroken for the families who've already suffered the greatest loss of all, of losing someone in their family, and I thank those who spoke to that today to uplift their memory and to make sure that we repeat their names over and over and over again. I also want to thank my colleagues who are here today who signed on as co-sponsors. I also want to specifically thank Commissioner Alma Anaya, who's been working on domestic violence issues for her whole tenure being here on the board and started these hearings years ago. And we're just working to continue them. And I look forward to the presentations from our justice stakeholders. Thank you.
Thank you. Thank you, Chair. This is on, okay. Thank you, Chair Moore, for recognizing me to speak, and I want to, of course, thank Commissioner Miller for bringing this forward. As the second largest county in the country, we know that Cook County deals with both public health and public safety, and it is our duty as a county board to understand how we are meeting or not meeting the needs of survivors of gender-based violence. I want to underscore the fact that we have here in Cook County have the great responsibility of ensuring that our systems work and that they do not further harm or in many instances put lives at jeopardy. I think what we've heard today in the testimony that we have just listened to underscores so much of why this is important. Oftentimes I talk about the fact that my mom was one of the lucky ones, one of the individuals that was able to get out of the situation after many years and actually survived the domestic violence that she experienced. And I think what was also brought forward today is the impact to children. As a children of a survivor, I understand the impacts of adverse childhood experiences. I've mentioned this before, but there are studies that specifically indicate that children who experience domestic violence at home can experience the same type of trauma in many levels, including behavioral health, and the traumas and effects of children that live in war zones. This is huge because we're seeing this in our county, and it is important that in our county that oversees both civil and criminal orders of protection, that our goal is to fully understand how the system works on both ends and how to be able to address issues if they are presented to us. In fact, one thing I want to highlight is civil orders of protection can be indicators for the likelihood of encountering domestic violence criminals and what that impact is in the future. Our goal today is to ensure that civil orders of protection are upheld in order for us to be able to prevent the fact that somebody is experiencing even further harm. The pandemic brought to light how much this issue is still relevant, and today's hearing will focus on what the county agencies can do to safeguard and protect the survivors and their families, whether someone is in the criminal or the civil side. Again, I want to thank Commissioner Miller and her team for coordinating this hearing and for continuing to advocate on behalf of all survivors. I also want to thank many of my colleagues who have supported these efforts throughout the years. Things like a 24-hour order of protections, access to court advocates, funding for the support systems. I know we approved about $2 million a few years ago for advocates in our emergency rooms in Cook County Health. We know that we're a touch point in many ways. So I want to thank everyone, especially the unofficial Women's Caucus that meets often and talks a lot about this issue and really wants to continue to make great work happen here in Cook County. So thank you, Chairman.
In the following order, Commissioner Daly, Commissioner McCaskill.
Thank you, Mr. Chairman, and let me also begin by thanking Commissioner Miller and with leave to add all members on this ordinance, on this resolution.
Leave.
Needless to say, I want to thank all the individuals who had the courage to come and testify. They are mighty in numbers, and you represent, even though you came, there's so many individuals who haven't come and testified. So we want to thank you. And I will tell you we're going to be starting public hearings on the preliminary budget, and then the budget is presented in October. There has to be a way we should and must coordinate the two. The reference about to Katie Dunn on your study, we look forward to hopefully implementing as much as possible, and at least discussing these ideas. In reference to the permanent order, if I would hope that we could look at this out of state, because I believe the only way it could be a permanent order could be issued would be a change at the state level. So we have many advocates. You have many advocates in Springfield. They will be going down in October. If there's a will, there's a way. They can't change this. I've seen serving in the General Assembly, they say they can't bring up items. Yes, they could bring any item they want up under a vehicle bill. We've seen it before, whether it be a stadium or whatever. This is an important issue that affects men and women and men of this county and children of this county. So I hope we will be hearing from the state's attorney, who in a short period of time, has made tremendous progress in this area, and I know wants to do more, as well as the representatives of the Chief Judge's Office. Thank you very much.
Pascal.
Good morning. I would like to first thank Commissioner Miller for continuing to bring awareness to this very important topic. And my point of being appointed to this position, this was one of the first issues brought to my office by Miss Sarah Brown and Miss Lakeisha Tate, who are advocates in the South suburban area for domestic violence, because we don't have the protections in our area, nor the housing, nor the advocacy, nor the resources to support those that are going through this particular trauma. It is imperative that, as one of the speakers stated, that we not only look at this from an adult perspective, but for the impact that it has on the children. It's not only impacting them in the home, but it resonates in the schools, in the behavior of their streets. So it's imperative that we look at this much more broader than just orders of protections for children, orders of protections for adults, but also for those of the children, and not only educate the police enforcement or the law advocates such as judges, but also our teachers. They need to understand how to recognize. So as we look at training, let us look at it on a much broader scale. Also, whatever efforts can be made to put funding towards housing for these particular victims in our areas, it is imperative that those dollars be made available. And I would hope that when we begin to go into our budget season, that we do give some recognition and some real consideration to enhancing or advancing funding towards this issue. Thank you.
Chair, thank you for convening this hearing today. I also want to say thank you to my colleagues, Commissioner Miller and Commissioner Anaya, for your leadership relative to this very important issue. I also want to acknowledge the good work relative to shining a light on this issue by our late colleague, Dennis Deere, who did so as well. You know, as we gather today, more than 36% of women and 29% of men experience contact sexual violence or rape, physical violence and or stalking by an intimate partner during their lifetime. This truth cloaks our clarion call. It's a clarion call for more training, a call for more transparency, a call for more communication and partnership, a call for more resources, and a call for less associated fees. I look forward to this hearing because I want to hear exactly how this call is being answered right here at Cook County. And as we do so, let's remember the words of Women's Aid, who said, "Everyone has the human right to live in safety and free from violence and abuse. Society has a duty to recognize and to defend this right." This board also has that duty. Thank you.
Degnan.
Thank you. I, too, would like to join the rest of the board in congratulating Donna Miller for bringing this important issue up today. I think she's been an excellent advocate and a continuing advocate for everybody in this space. And I also know that Commissioner Alma Anaya has also joined in that work. Hearing the heartbreaking stories today and the stories that we've heard previously just really highlights for all of us, I think, how much work there is to continue to do in this space. I think, number one, we need more data. I don't know that any government is perfect at collecting data, but I think the data that needs to help support changes in this area needs to be collected and circulated by the Office of the Chief Judge, by the Clerk of the Circuit Court, and anybody else that touches these matters. I think secondarily, too, that we all receive sexual harassment training, we receive politically protected activity training. We receive trainings throughout the county for a number of different important issues. So I think it's imperative that mandatory training happen for people in family court so they can best serve and protect the people who are victims and continue that. So I look forward to the other presentations we have. I have a number of questions, but I'm excited to hear from everybody, and I know that this board is very committed to encouraging changes in this area.
Commissioner Aguilar.
Thank you, Chairman. First, I want to thank my colleague, Commissioner Miller and Commissioner Anaya for putting attention on domestic violence. And I want to thank the folks that are here for your bravery, your courage for testifying. And it's important that you let us know and speak out on this issue. You know, we read many cases where the victim becomes the perpetrator and then the perpetrator becomes the victim. And that's really a tremendous assault on justice and focus on this right now, especially now. We must speak up because what's going on in Washington, D.C., unfortunately, is our judicial system is breaking down. And instead of being more justice, it's becoming more injustice. And I'm glad to see folks like you and speaking out on this issue. So I want to be a co-sponsor. I guess we're on leave to co-sponsor this resolution. Thank you very much. So again, thank you for being here.
Stamps.
Thank you, Chair. Thank you again to Commissioner Diane Miller for taking the lead on this and all the support, and thank you for the victims who have come forward. I think just by the testimony and the comments and the statistics that have been put forward, I don't know how this works, Chair, but maybe we can investigate it. I think that maybe we are in a space where we may need a criminal justice hearing, where we're bringing together the state's attorney's office, the JAC, and the public defender's office, because we are spending a lot of money in housing. We're spending a lot of money in crisis, in trauma. And so where is the correlation between the money that we're spending and how it's being addressed and the issues that we're hearing right now today? I think that's something that everybody on the board would want to be aware of. And I think that more than anything, we want to make sure that we're participating in real, true advocacy and solutions and restorations of peoples whose lives have been torn asunder and have been twice, thrice traumatized, A, by their initial victimization, secondarily, by any reaction that you may have from family and community, and then thirdly, what happens in the actual court system for women and men who lay their lives bare in hopes of support and protection, and they do not receive it. I cannot tell you how many times, whether it's been in my own family or parents or even students from the many years that I've taught that have felt ignored in this system when their lives go into this direction. And I think that we are the body that are in place to perhaps input some corrective action to really make sure that the voices that we heard today and the ones that they are representing get heard, and that our children are prioritized. And, you know, because everybody knows that I have a heart for young people, this also is manifesting itself, and these numbers are increasing in younger people. Domestic violence in youth is on the rise. Incarceration for these kinds of gender-based crimes are on the rise in our communities. And then we, or people like me who have the blessing of wearing a lot of hats, but as a public school teacher, see and how the unresolved trauma impacts learning, impacts nutrition, impacts every way of life, and not in a good way. It informs their decline. So again, I want to thank Commissioner Miller and Anaya, but I think that this warrants some real inquiry into the bodies that can most impact it and make some not only monetary changes, but I think you even spoke to, where Chairman Daley even spoke to what can happen in terms of a permanent order of protection at the level of the General Assembly. So I think that not only do we need to create an opportunity to have a criminal justice hearing, but I also think that we may need to be in communication with our people at the state level to see where do we really bring about real life-changing resolutions that can improve the lives of women and men who are being victims in their own homes by people they love.
Thank you, Chair. And I also want to echo my colleagues' appreciation for Commissioner Miller and bringing this forward and the work that Commissioner and I have done. Not quite 40 years ago, I was the victim of stalking, and it was a different era. And I vividly remember the struggles I had getting the Chicago Police Department and the state's attorney to actually take my concerns and complaints seriously. And in the end, nothing was done. I am happy to have witnessed over the past 40 years that there have been changes made. Things are better in terms of being able to report and getting some kind of response from the system. But the stories that I've heard today brings home to me, and I think to everybody, that there is still a whole lot of work to do to ensure that victims of domestic violence can work in a system that doesn't in turn make them into victims. And I just, I think that we as commissioners need to listen to this and advocate for those changes to make sure that the system does in fact work to protect people in this situation. Having been in this situation myself, I fully appreciate the challenges that they face. Thank you.
Thank you very much. So first of all, thank you for all the speakers and all the people that have done a tremendous amount of work, including those who do so in their day job. There are many existential problems with this issue: violence, gender, shame, fear, economics. Those are not things we are able to do anything about. But I would like to remind everyone that there are things that we are able to do things about. We can require, or at least investigate, the requirements around the court system at creating transparency on civil orders within the bounds of what is reasonable for the privacy of all involved. We can require the sheriff to report on the number of orders that are issued and served, and then the outcome. We can require the clerk to publish these records and data, as is done with so many other issues. And these are all things that we can do, that we have the power to do, and we have the power to request. As Chairman Daley reminded us, mid-year budget hearings are next week. All principals will be before us to answer the questions about the resourcing for their next year. And the question is, there have been incredibly compelling stories here, all of which have highlighted things that were failures of the system. And knowing that each side of any argument needs to be protected and has reasonable rights, the thing that needs to happen now is there is an enormous amount of room for empathy, but we have to be incredibly strategic about requiring the things within the bounds of what we can do, and then pass those, whether it's the Illinois court system and the Supreme Court, highlighting to them the things that exist. And so separating out what's in the law, what's in the policy, and then what is just in practice are three very different things that we should be focused on for next week. And I hope that all of the emotion of this day carries itself over to the hearings next week. Thank you.
Commissioner Miller.
Thank you. I just wanted to add, first, thanks to all my colleagues for all of your support and comments and time and attention focused on this. As we know, and we hear many of these stories, they're not just stories because they affect some of us on a personal level, and my sister was one of those testifying today. So when the impact on families continues for decades, and when we look at the things that we can implement and the things that we can actually do, there's a story behind it. And so all of you who told your stories, you're going to propel us to move with the accuracy and determination and the focus as we look into our budget. But don't forget that public testimony is today and also at our budget hearing. So I would encourage you to participate as well in that process and help us make the stories mean something that translate into actionable items. So I look forward to, again, the testimonies that we're going to have from the departments from within the county. And when we look at how change can happen, I still want to thank Katie and Carmen for being so diligent on this issue, never giving up. And we're not finished. I'm just saying that we have work to do, and you've coalesced such a group of people to help you do that work. And I'm proud to be part of that.
Thank you, Commissioner. Now, the following individuals will be presenting at this committee. Representatives from the State Attorney's Office, Chief Judge's Office, Sheriff's Office, Public Defender's Office, Clerk of the Circuit Court, and the Public Guardians. The first up, taken out of order, the State's Attorney, please come on up. Attorney Eileen Burke.
Thank you to Chairman Stan Moore and Vice Chair Tara Stamps for your leadership in this area, and thank you to Donna Miller and Alma Anaya for convening this. This is an important topic, and I'm so grateful to have the opportunity to talk to you. I took office in December of this year. Since December of this year, according to the Chicago Police statistics, in Chicago alone, we have had 39 women murdered in a domestic violence situation. 39. That is a shocking, shocking number. I thought my priority and my sole focus was going to be on gun crime. I learned very, very quickly that we had a second house on fire, and that was in our domestic violence situation. The percentage, while we are getting some traction on gun violence, our murder rate has decreased significantly. However, the murder rate of domestic violence situations has gone from 9% of the total murders in 2024 to date, it is 17% of the total murders. That is a shocking number. So it is a problem that we need to address, and we needed to address it quickly. So the first thing we did is we took a look at how are we addressing certain types of crimes. So domestic violence, sexual assault, hate crimes, crimes against children were all in different areas, in different fields of expertise. So we decided that when we have these types of crimes, they need to be in one bureau. So we created a Special Victims Bureau. And the Special Victims Bureau has sexual assault, domestic violence. Thank you. There's a chart showing what we have. Human trafficking, hate crimes. There are a few crimes that we want to build, that they're aspirational for us right now. And one of them is we want to have a domestic violence murder specialist, specifically in this category. And the reason why we needed to create an entire bureau is multifold. One is we want to have training for our assistant state's attorneys so that they understand that a traumatized victim has to be handled differently. We do not want the court system to be re-traumatizing them all over again. So in order to have the specialized training for those, we put all of these crimes in one bureau. We are already developing a curriculum for our state's attorneys to go through to understand how victims process things when it's these types of crimes. We also wanted to do this as a bureau because we believe that it will attract a different kind of person. It will attract a specific type of prosecutor who wants to walk through this system with somebody. The model is a vertical prosecution model. In most of the felony sexual assaults, we now have a vertical prosecution model, which means you are not going to be handed off to several different state's attorneys. You will have one state's attorney from the beginning. This is significantly minimizes the trauma that people have as they're coming through the court system. The other thing that we knew we had to address quickly was first appearance court. We had a very low detention rate for people who were domestic violence perpetrators. So what we did immediately is we embedded 2 of our investigators over there. We found some logger jams quickly. Some of the logger jams were we could not access any information that was in an order of protection that was not served. So there could be 5 orders of protection, but if they weren't served, we couldn't find any of that information. We couldn't access it. We couldn't present it to judges when we were going in front of a detention hearing. Abuse and neglect cases, which are now called child protection, we couldn't access any of that information. We couldn't access any domestic relations orders of protection. So many of the survivors who testified today, they had civil orders of protection in domestic relations court. The state's attorney's office has no involvement in that. So we couldn't get any of that information. So we immediately went to the Chief Judge's office and said, we need access to all of this information in order for us to go in front of judges and give the fullest picture that we can on why someone presents a danger. So we now have access to that information. Our detention rate on domestic violence perpetrators has gone up significantly. We also have victim witness personnel in our domestic violence. I almost said domestic relations, and that it's mess everybody up. So it's domestic violence is where the state's attorney's office is involved. Domestic relations is divorce cases. State's attorney's office is not involved in any of those proceedings. So in our domestic violence courthouse, we have victim witness personnel who we want to get our victims with them as soon as possible so that we can get them having access to services. We can get them the support that they need in order to continue in the court process. We are understaffed in victim witness, and that is also aspirational on how we want to change this bureau to make sure that we are adequately addressing the needs of everyone who comes through there as a victim. I am not an expert in this, and I do have a gift, and my gift is that I am really good at finding talented people, and I talk them into doing things that are way, way harder jobs. I found an extremely talented woman in Ann McCord Rogers. She was a prosecutor for 23 years. She has had every single position in sexual assault and domestic violence. She was the person I went to when we started forming this bureau. And she was the person that I knew had to be the bureau chief, along with Tanae McCoy Cummings, who is her deputy bureau chief. And so I am going to turn it over to her to explain the process.
Thank you very much, State's Attorney Burke. Thank you all for having us here today. When State's Attorney Burke took office, she made domestic violence and sexual assault a priority, and that was evidenced by the swift creation of this bureau, as you just saw. In this bureau, we have approximately 75 assistant state's attorneys who are in domestic violence, sexual assault, human trafficking. These 75 assistant state's attorneys are specifically trained to prosecute cases from a survivor-centered approach. We have training. We are continuing to formulate and roll out very specific training for these they're in their career on the felony level. We also utilize a support dog. We are seeking 2 more that has been very successful in the prosecution of cases involving children. The dog's name is Hattie. Hattie is all very involved in our cases, and we have seen children willing to open up more, and so we're looking to expand that program into adults. This is how currently we are staffed, and as the state's attorney said, we do not currently have a felony domestic violence unit. We have a misdemeanor domestic violence unit that handles 555 West Harrison and the suburban district misdemeanor rooms. Felonies, we do not have a unit dedicated to felony domestic violence and homicides. The result is that survivors are not seeing the same experience throughout the prosecution and do not receive the benefit of a specific trained attorney who will vertically prosecute the case, meaning from the beginning to the very end. And that brings us to what aspirationally we're looking to do. The next slide, please. State's Attorney Burke has a vision to allow all survivors to be afforded equal treatment across the country and grow across the county and grow this bureau. In this vision, there is additional prosecutors assigned to the sexual assault unit. There is a child abuse unit created that would work in tandem with our attorneys in the child protection unit that would prosecute child physical abuse cases. There would be a hate crime specialist, and most importantly, there would be a unit created that would handle felony domestic violence cases and homicide cases across the county. This model would increase the staffing and strength of our domestic violence division. This is a division that's responsible for all aspects of a case and interacts with survivors of domestic violence in many, many ways. I think it's in order to understand the function of this division, particularly in domestic violence, it's important to understand how a felony case and a misdemeanor case flow through the system and how a survivor, when faced with a very traumatic event, interacts across his or her pathway through this system in order for them to achieve safety and justice. So the first thing we wanted to talk about is what types of charges we are looking for. The next slide. The most common charges that we see in misdemeanor cases are domestic batteries, violations of order of protection, criminal damage to property, electronic harassment, and aggravated assault. The felony level are aggravated domestic battery, so there's just an additional factor that aggravates the crime to a felony, and attempt murder, home invasion. These charges are all perpetrated by a family or household member of the survivor, frequently a spouse or a domestic partner. These survivors have been harmed by one of the people they trust and love most in their life, and are now turning to the police and the court system to follow a process that is our job is to ensure that every survivor understands the process, is met with patience and kindness from trained police and prosecutors. How a survivor will go through the system depends on if the charge is a misdemeanor or a felony. The next slide, please. The majority of domestic violence cases that enter the criminal justice system are misdemeanor charges. So in those charges, a police officer responds to the scene, and the question of what pathway that case will take is dependent upon if the offender is on the scene. If the offender is on the scene, which is noted in green, the police will make the determination, is there probable cause to arrest them? If there is, that person is brought to court for a first appearance hearing. At that stage, the assistant state's attorney will determine if the state is seeking detention and prepares the case to be presented before a judge. During this process, the victim witness personnel who are part of our bureau contact the survivor and determine if they would like an order of protection on that first court date immediately. As State's Attorney Burke came in, one of her first policy changes, as she spoke about, was the change in our detention policy. This policy gave us clear guidance on when we should and should not be filing for detention. Another meaningful change is, as part of this process, State's Attorney Burke embedded investigators with our assistant state's attorneys. This allowed us to obtain records from police departments that were not just the case at hand. We always had the police reports that were at the case charged, but as we all know, the analysis on a domestic violence case is much deeper than what's presented on the paper in front of us. So we had to find out orders of protection, old police reports with this survivor and others, beyond the criminal history that we would look at in any other type of case. So the investigators were helpful, but we had another obstacle, which was our access to Odyssey and our access to orders of protection in domestic relations. State's Attorney Burke worked with the Office of the Chief Judge and the Clerk's Office, and we then had access to orders of protection across civil and criminal, which helped us a lot be able to present a full picture to a judge when they determined detention. That case, if we are then presenting to the judge and the case is either detained or released based on the judge. If the person survivor does not wish to proceed with criminal charges at any point, they have the option to go to civil court. The civil proceeding is an order of protection hearing that is independent of the state's attorney's office, and we do not play any role. In the event that the offender is not on scene when the police arrive, the survivor is given a police report, and they will go to either our screening division at 555 West Harrison, or the police, or the various suburban districts have different ways that the police will inform the victim of what they need to do next. Once the case is screened, they speak with an ASA. At that stage, we have survivor engagement specialists. They are present for a survivor in the event that there are not criminal charges filed, and they can provide resources, provide assistance, and follow up with those survivors that are not going to engage in the criminal justice system. The case then follows the similar path after the charges are approved, and the survivor will then ultimately the case being assigned to a misdemeanor courtroom. If in the case that the state's attorney's office declines to prosecute charges because there is just not enough evidence for us to proceed, that survivor has the option also to go to civil court. And in civil court, that's where they would receive an order of protection independent from the state's attorney's office. Slide, please. In the case of a felony charge, the police would respond and the case is assigned to a detective who investigates the case. The state's attorney's office has a felony review unit that works 365 days a year, who reviews the police reports at hand, interviews witnesses, reviews the criminal history. There is a specialty prosecutor on call for this process from the Special Victims Bureau who makes the ultimate decision whether the case is approved or rejected. A felony approval follows the same path as an approved misdemeanor. However, the case will end at a felony courtroom at 26 in California. In the event the case is not approved, the police can charge the case as a misdemeanor, which will flow the case into a misdemeanor courtroom at 555 or a suburb, or the survivor may seek the civil order of protection. We are constantly striving to make improvements to our Bureau to provide survivors with all of the support they need as they navigate a system that is sometimes difficult to understand. But we are here, we are present, and we are seeking to build as we continue in our mission. I want to thank you all for your time.
Are there any questions from any of the commissioners?
Thank you for being here with us, Attorney Burke. With regard to the comments and the reports that were given by the speakers today, my concern was with regard to judges that don't seem to have a lot of oversight. We heard the names of several judges mentioned quite often. So I'm wondering, in your office, what steps are going to be taken to actually receive these complaints and actually begin to provide more oversight for these judges, or at least investigate the concerns that are coming from your victims?
So this may be the first time I was ever grateful that I wasn't a judge anymore when I heard the survivors testify. But the role of the judiciary in the state's attorney's office, we don't investigate judges. There is a body that investigates judges called the Judicial Inquiry Board. It is separate and apart from the state's attorney's office. In addition, many of the survivors who testified earlier, those were all in domestic relations court. And again, the state's attorney's office has nothing to do with domestic relations. That's divorce court.
Thank you for that. That was helpful. So now they at least know to where they can direct their concerns, the Judicial
Inquiry
Board. Thank you.
Next is Commissioner Daly. I'm sorry, taking questions from the audience, from the commissioners.
Thank you, Mr. Chairman. And State's Attorney, thank you for your presentation today. Needless to say, in a short period of time, you've done a lot of reorganization. As we move forward in the preliminary budget, I know you had asked for, and I read it in the paper, I should say, about a case management.
Yes.
Has that been submitted, and are you working with the administration on that aspect as well as the requests that you have and you showed today?
So a case management system can give us a lot more data than we currently have. Right now, we have assistant state's attorneys who are keeping track of their cases with Excel spreadsheets. That is not a system that is conducive to transparency. We have met with the public defender and we have met with the Office of the Chief Judge about getting a system that all of us can benefit from, that we would have safeguards in place on certain things, but that a system that all of us can, and the circuit court clerk as well, that all of us can have a system that communicates with each other, and that could be a huge step forward for data transparency for all of us. That is what we want. We want to know if what we're doing is making a difference. Because I'll tell you, Commissioner Daly, I got into this to make a difference. If I'm not making a difference, I want to know that. I don't want numbers telling me that we're making a difference if we're not. I want to know if we're not making a difference, then I want to know we have to pivot and try something else. So it is imperative for us to have a case management system that can give us access to that information.
And I think, because working together, all three, and with safeguards as we know have to be implemented, I think is much more reasonable and makes sense. In one of the presentations, I think you had a misdemeanor is a violation of a court order.
So if there is a civil order of protection, and please, Ann, correct me if I'm wrong, if there's a civil order of protection and somebody violates that violation of an order of protection can become a criminal case.
Can. So
yes.
There's no reason, will we have to change the law to make it a felony? Because right now it's only a misdemeanor, right? Or you have the authority, is there the authority to raise it up to a felony? I saw it as misdemeanor, and then the other side was felonies.
If there is a prior conviction for violation of order of protection or other certain offenses, it would be a felony based on criminal history.
Okay, so right now there is that authority.
Yes.
Okay.
Yes.
Thank you.
Thank you, Chairman. State Attorney Burke, thank you for being here, and I appreciate all your work that you've done, especially gun violence. I've seen your work result in my district. You mentioned something that caught my eye, that caught my attention. You said that you did not have access to the history, and correct me if I'm wrong, to the history of a case of a domestic violence, that if you would have had the history which could be used as evidence, that maybe this could probably help you maybe prevent a serious result. It could be results could be fatal. Is that correct?
So if there was a prior order of protection, but it was not served, we could not get access to that information. So if somebody had 5 prior orders of protection against this victim or against any victim, we couldn't get access to that information, but we can now.
You can now. Okay, thank you.
Miller.
Thank you. Thank you, State's Attorney, for being here. Thank you for explaining this very intricate process that you jumped on right away, and I appreciate you doing that. And I do just want to make clear that some of those who testified today were in domestic violence court. So I think that one of the things that you mentioned, the coordination of what happens in domestic violence court and domestic relation court, is where we have an issue that you've already addressed part of that issue. But I think that some of the people who testified still are being caught up in that entire system. And when we work to make the future changes, I know that you'll be focused on how we can make that part even better and what it looks like for these survivors, and hopefully have some more in-depth conversation of decreasing the time frame, because 7 years in court, 5 years in court, when someone did mention that we do have a state mandate of what that time frame should look like, we're way over it. Yeah. So I'd love to just hear initially, do you have ideas on how you can make those changes quicker?
So with regard to domestic relations, there's very little impact that we can have. That is an Office of the Chief Judge issue, and we are more than amenable to meeting and talking. We've met with all the presiding judges multiple times, and we will continue to do that. We will figure out what the loggerjams are, and to the extent that the state's attorney's office is part of that loggerjam, we will resolve to fix it. But as it stands now, we're not part of domestic relations. But I agree with you. The cases are not like wine or cheese. They do not get better with age. They get worse. And so there is a reason why we have time limits on cases, and we need to make sure that we are adhering as closely as possible to those time limits, because that's due process, not just for the victim, but for the defendant as well. So, thank you.
Morrison.
Thank you, State Attorney Burke. Ironically, if you sit around long enough, a lot of your questions get asked and answered. But I just want to touch base on this, and just to be clear for the purpose of the public out there, we are now able to get access to the Odyssey so that we can run those screenings.
Yes.
We had testimony that they weren't screened. People had 5 previous, and the judges.
This is new, though, Commissioner Morrison. This
has come in the last 6 months.
Yes.
Yes. And thank you for that. And by the way, side note, thank you for a lot of the other things that have been changing in the last 6 months. Redressing our policies and procedures should be ongoing. To that point, so a few of the things have been asked, so I'm going to speak to this. Another ironic nature of this is in the Pretrial Fairness Act, domestic violence is actually eligible for the release. You wouldn't think that it would, but if you're around government long enough, things that you think would be common sense and part of it, you find out that they're not. I'm glad to hear, though, that it takes a state's attorney in order to request that on a specific. I'm glad that you've embedded these investigators. And to Chairman Daley's point, a few of the things that probably need to be done here have to be done at the state level. They've got to be done through legislative action, and I think all of us should probably get together and make sure that our legislators and state reps understand that this is something that they really need to address and take up. Like Chairman said, they could do this if they had the political will to do it in October. So maybe we can all press for that. Maybe with some guidance from you and from the Chief Judge's office, we can find out exactly how that should be structured and worked, and then have everybody pulling the train in the same manner.
We do have a legislative team, and my chief of policy is here as well, and this is an issue that is top of our mind. What legislation are we proposing, as well as what legislation can we push along saying this is a good idea?
Yeah,
so,
and precisely what I'm referencing on that one was a testimony on the permanent restraining orders, and I do believe there are states that have those orders in those states. Some folks get arrested in different counties or states, and they realize that things are entirely different when they went across a line as to what their eventual culpability is going to be. So those are the 2 topics that I wanted to mention. And then there was one more thing, and you brought it up briefly on the 555 Harrison. There was a lady here that mentioned, they just pointed out about how intimidating it can be and how scary it could be, and that she was fraught with fear. Just on the notion of trying to go into 555 to get it, she was worried about her safety. If that's something that perhaps us and the sheriff can just take a look at on a side note and see if we have an adequate visible deterrent that would make those folks feel better. And by the way, I just want to take a moment to thank all those folks that came with that testimony. It was very, very powerful when things like that occur. And there's really nothing more important and more impactful that we can do as a board as to offer that type of empathy and respect for the men and women that do go through this. And then my final thing would also be to echo again, we are coming up to budgets. If we need these extra investigators, if we need these extra state attorneys and prosecutors, now's the time to ask for it. Now is the time to ask for these types of things. If we need housing, some of the folks out there, if we need these shelters for these domestic battered families and children, we need to ask for that now and make the case for it, and then we'll have to work on it and see how we can make that come to pass. And I want to thank you. Thank you for your time.
We have not been shy, Commissioner Morrison, in what we are asking for in the next budget. And believe me, we did a very thorough analysis of what is necessary for us to do our job. So thank you.
Appreciate that. Thank you.
I think I just heard Commissioner Morrison agree to a budget increase.
I think he did.
Okay.
Well, that is true. And believe me, Chairman, that was going through my head as I was saying it, but you know me, I like to be a fiscal hawk, but I'm also very big on spending the money if the money's spent in the right manner.
Understood. Thank you.
Thank you.
Commissioner Anaya.
Thank you, Chair. Thank you, State Attorney, for being here in person. We truly appreciate it. But I also want to thank you for very early on after you got elected and inaugurated. You reached out. We went in depth in conversation regarding gender-based violence, specifically domestic violence, and I'm very appreciative to hear all of the updates that you've been able to present today, especially with the new Special Victims Bureau and all of the efforts. So I want to just first thank you personally for that. So some of the things that we discussed at the initial meeting were some of the maybe hiccups that we foresaw with Karina's bill. Do you have an update on that? I know it wasn't fully addressed, but I just want to make sure that at least at that end, things kind of got ironed out. If not, what else can we do to be supportive of that?
We had several significant concerns about Karina's bill. One is there is no law enforcement component attached to that bill. So there is several. I could get way into the weeds with you on this one, but so let's talk offline about it. But I do want to raise some concerns about it and raise some amendments that I think that would be beneficial to victims and law enforcement in getting these done.
Okay, perfect. Yeah, we can definitely set that up. In regards to some of the training that you discussed earlier, so you discussed, the Bureau being set up and some of that training being incorporated. Is that training already underway? Is that something that's going to be done on a yearly basis? How do you foresee that?
Actually, the training is we brought in a director of curriculum, and we have instituted over 24 new trainings, not specifically for domestic violence, but for all over the system. My goal is judges go on a thing called an education conference. Half the judges in the state go 1 week and the other half go another week. So my goal is to have our own education conference. Your judge is at EdCon, you're going to EdCon. And the goal is to have a sufficient curriculum that everyone can select what they want to take. Domestic violence is different because we are so trauma-informed and trauma-based in the Special Victims Bureau. That is ongoing. We've been working with NAMI quite a bit. We've been working with other stakeholders on making sure that we are addressing it. The network is part of our transition committee to make sure that that training is, and it's not going to be yearly, it is going to be on a monthly basis, that we are going to continue to address what are the changes in the statutes, what are the changes in the case law, and what are the best practices for leading victims through that process. So it is a fulsome program, and we've already implemented an orientation program before an assistant in domestic violence. That is a misdemeanor call, which means you're younger in your career as a state's attorney when you go there. Well, we used to, when I was a state's attorney, they'd just throw you in the deep end and say, here's a stack of files, go to it. That's not fair. I hated learning that way. And it's not fair to the victims who you're greeting that day if you're brand spanking new in that courtroom and you have no idea what's going on. So what we have implemented is an orientation program. Before you step foot in any courtroom, you will go through an orientation program. So you know what the statutes are that govern that area. You know what the best practices are before you start talking to a victim. But it also lets us know if somebody is equipped for that type of work. This is not for the faint of heart. These are the cases that wake me up in the middle of the night. These are the cases that stick with you for decades, that you come back to again and again and again about what happened. So we need to make sure our state's attorneys are ready for that.
And that would be for all of the ASAs, correct?
Yes.
So everybody is going to have access. And
Yes.
Okay, thank you. Just curious about, we talked about the orders of protection. I know there was a few mentioned, the fact that sometimes it does feel like just a paper. Sometimes there's a lot of violations that happen with orders of protection. Is your office looking at, enforcement in regards to any violations with orders of protection? And again, how can, we improve that if there are any specific issues that are occurring?
We take violations of orders of protection very, very seriously because it indicates, okay, there has already been a domestic incident and now we have put strictures in place that you need to comply with. And in spite of that, you have violated that. That means you are defying court orders. So we address those very, very seriously, and they're very important when we're going into first appearance court if there is a history of violations of orders of protection, because it indicates someone has already defied the regular course of activity and they have already shown that they're a danger in spite of that. Did you want to add anything to that?
Yeah, and when we receive them in first, that's a mandatory filing. We will file for detention on every one of those cases.
Okay, appreciate that. So you talked a little bit about coordination with domestic relations, and I can't underscore enough how important that is. I know that there are different entities and different bodies. Obviously, they both have a different principle and different maybe ideals or procedures. But I just wanted to, this is not really a question, it's just I can't underscore enough how important it is for there to be continuous communication, which seems like there is, but just ensuring that remains, because I think Commissioner Miller mentioned how many people get lost in the middle, and I think that it is confusing, and sometimes when we don't have the appropriate advocates or important information presented to us or resources, it does become a very cumbersome system. It becomes something that a lot of folks are kind of throwing back and forth, and it really, just historically, just by talking to advocates, sometimes people abandon their cases because it really
it's become too difficult.
Exactly, and there's no sense of hope through the process. And if it's a lengthy process, if it's something that's just not getting anywhere, it just creates so many issues.
And if I could give you an illustration of what you just talked about, was we had a case, and it was before I came in, it was last fall, where a person came and the state was asking for detention. And the judge said, well, state, why are you asking for detention on this? Because the allegation in the detention petition was this man, in violation of an order of protection, left a basket of gifts on his ex-wife's porch for his children. That's the allegation. So the judge said, state, why are you asking for detention on this? And at the time, it was a brand new state's attorney who was in front and said, I have no idea. So the judge, luckily, had the ability to backdoor into the system and pull up the original divorce file. In that divorce file was an order of protection wherein the defendant had taken the children and absconded with them to another state, and they had to be removed from a hotel room by the state troopers or whatever law enforcement entity it was. Children were completely traumatized. Well, that is a very fundamentally different situation than I just left gifts for my kids on my ex-wife's porch. That's why we need that information. That's why we needed to have access to the divorce files, to prior orders of protection, to civil orders of protection. I cannot emphasize enough how important it is for us to go into a first appearance court with every bit of information that we need to have.
Appreciate that. And yes, that's an example, but you're right. There's so many other cases that may seem so little details that are extremely important for us to get the back information on that. The last few things. So another thing, I think a common thing that I heard today was regarding some of the hiccups maybe in presenting a real case, or maybe certain things that were overlooked in a process that led maybe the children to still be in custody of sorts with the perpetrator. So do you feel like you have enough time and resources to adequately present these cases in its entirety?
We have improved in our processes. I believe there's going to be more rooms opened up to do, for us, it's first appearance hearings. We can always use more ASAs to be able to present these cases in a thorough manner. We are doing the absolute best we can with the resources we have. I think a lot of what was spoken about today was in domestic relations court. And those orders of protection and those pathways, we do not have, as the state's attorney's office, we just do not have any input. And we handle a case when it comes as a criminal charge. We can give an order of protection attached to that criminal case. But if it is in the civil, if somebody comes to 555 West Harrison and they end up in a civil courtroom and there's already a divorce pending, that case will go, and it is completely separate from the state's attorney's office.
So do you mean it automatically gets shifted off into relations?
Yes. We do not
have. Is that 100% of the cases, or is that in certain?
So only if there is no criminal charge pending.
Okay.
We only will handle an order of protection, the issuance of an order of protection, in the event there is a criminal charge pending. Mm-hmm. However, we do prosecute violations of any order of protection, regardless of origin. But we can only issue the order of protection when there is a criminal case pending.
Okay. Appreciate it. My last question. Another thing we heard a lot was victimizing a person, either the survivor or the children, family, etc. Have you all looked at what type of internal processes within your office can help prevent any adjustments to help prevent victimizing the people that are going to you for help and assistance?
I think first and foremost, we need to understand how people who have been traumatized behave and how they react to certain things. And that's important for our state's attorneys to understand that. If somebody is reticent to talk to you, well, maybe it's been a horrific experience up until this point. Maybe they have tried civil orders of protection and they think this is going to be the same thing all over again. So a lot of it is informing our victim witness personnel, who are excellent, and informing our state's attorneys about how to approach people who have been traumatized so that we can get them through this process without dropping the case, without saying, the system just is broken and it's not working. That's what we're focused on.
Yeah, and that would be great to incorporate within the training as well.
Mm-hmm.
Okay, thank you. Those were my only questions. Thank you, Chairman.
Good afternoon, State's Attorney. And Ann, I'm so sorry I forgot your title.
Bureau Chief.
Bureau
Special
Chief
Victims
Ann.
Bureau.
Thank you both for being here. I'll be very brief with my questions. So earlier, you all mentioned that there are 75 state's attorneys that prosecute from a survivor-centered approach. I wondered if you could touch on language access and capacity around language with those attorneys.
So that is a struggle for us. And we have a very small number of people that speak Spanish, but other languages are very difficult. We will have to get with the interpreter's office in whatever building they're in and get an interpreter. We do have victim witness who does speak and can communicate many different, but they are finite in number.
And so with this vertical prosecution model, if there is not an attorney that is able to speak the language of the individual, then it's pairing with an interpreter to help.
Yes.
Okay. And then with these victim witness personnel, individuals, are those attorneys? They're not attorneys? No. Okay. And are we partnering with any nonprofit organizations around some of these services and referrals? Mujeres Latinas en Acción, for example, has been around for decades, and I think they're a resource in this kind of work.
And yes, there is actually a domestic violence resource manual that we have our victim impact specialists have created. And it is a list of a multitude of agencies, and depending on the need. So we definitely partner. We refer constantly to different agencies in the community that are community-based.
And so with the victim witness personnel, if they are not attorneys, what kind of licensure or what kind of professional skill sets do they have, or are you looking for?
So they are AFSCME represented. They receive specialized training in how to get a victim through the system. They also know how the system works. They know what the next expectation is. It is an absolute priority for us to have as many people who speak Spanish as possible in those roles. That is one of the main sources of our victims are the Latino population. So that's a priority. Their criterion, go ahead. What is their hiring criterion? They're excellent, though. I have to tell you, yesterday we were at Officer Vasquez Lasso's trial, and those victim witness personnel were with his family through the entire process. By the end of that process, I have seen multiple times that they are very attached to their victim witness people. They are with them at every single court date. They are talking to them between court dates. They are always with them. And it is truly, they are very special people, the victim witness people. They are so good at their jobs. So it's a priority for us.
Could you speak to?
I can't speak specifically. I know personally many of them are licensed clinical social workers, and that is their background in their training or where they're schooling. But I can't speak to the qualifications as it goes out in like a job posting.
No, thank you. I would just like to stress for my district, and I'm sure if Commissioner Morita was here as well, cultural competency and language access is critical. And so I really hope that we center cultural competency and language access in these positions, as well as looking forward into any reforms. Very quickly, also, are there any considerations for immigration status? Because
No.
as you know, no? Okay.
So, anytime you bring a large population of people into an area, a large population of desperate people, you will have an increase in victims. You will. That's just the reality of it. Sex trafficking, human trafficking, wage labor, all of those things will increase in that population. So we never ask a victim or a defendant what their immigration status is, nor will we. We do not want to discourage people from coming forward if they're a victim of a crime. The only time a defendant is asked what his immigration status is during a plea when a judge has to admonish them if they are not a citizen of the United States, and they admonish them that they are entitled to talk to their consulate before they take a plea. Other than that, we will never ask what their immigration status is.
Fantastic. I cannot tell you how important it is for our immigrant community to hear it from their elected officials. So thank you so much for that. And before I yield my time, I would like to thank so much the Unofficial Women's Caucus, who has been working on this for a very long time prior to me being here, specifically Commissioner Donna Miller and Commissioner Alma Anaya for your leadership on this. Thank you.
Before I take the next commissioner, I'd like for Commissioner Gaynor.
Thank you, Madam, and pardon me, this will be very brief. Madam Secretary, would you please call the roll quickly for the, I believe it's workforce first and then Bureau of Economic Development?
Business and Economic Development
Yes.
first, ma'am. You ready?
Yes, I am.
Thank you. Here's roll call to call in Business and Economic Development scheduled for today at 10:30. Vice Chair Anaya.
Present.
Commissioner Britton. Commissioner Laurie. Commissioner Miller. Commissioner Moore.
Here.
Commissioner Morita.
Morita present.
Commissioner Morita is present and participating remotely. Commissioner Kevin Morrison is absent. Commissioner Sean Morrison.
Sean Morrison present.
Thank you. And Madam Chair is present.
Thank you very much. This will be recessed to the call of the chair. Could you please call Workforce, Housing, and Community Development?
Workforce is also scheduled for today at 10:35. Roll call is Commissioner Naya.
Present.
Commissioner McCaskill. Vice Chair Miller. Commissioner Morita.
Morita present.
Commissioner Morita is present and participating remotely. Commissioner Scott.
Present.
Commissioner Scott is present and participating remotely. Commissioner Stamps. Commissioner Trevor.
We're here.
Commissioner Vasquez. And Chairman is also present.
Madam Secretary, just one point of order. Do we have to allow for remote participation for people to call into the roll, or can they just call for?
You can do your remote roll call once the meeting begins.
Okay, thanks. While
So
we're
you
at
do
it,
have a quorum for that meeting.
Great. I'd like to recess that to the call of the chair. And now will you call the Pension Committee?
Pension is also scheduled for today at 10:45. Roll call is Commissioner Daly. Commissioner Miller. Commissioner Kevin Morrison is absent. Commissioner Scott.
Present.
Thank you. And participating remotely, Commissioner Stamps. Present. Thank you. Commissioner Trevor.
Trevor here.
And Madam Chair is present. Madam Chair, you do have a quorum for this meeting as well.
Thank you. I'll recess that to the call of the chair. Thank you. So pardon me, Madam State's Attorney. Is it my turn to speak? So a couple questions. What I want to try to help us understand is to separate out, there's resource issues, there are statutory issues that require the legislature in Springfield. There are issues that are either the Supreme Court or the chief judge that orders have been promulgated. And then there's often things that are practice or technology requirements or other impediments. When you think about your ability to execute the vision that you've just spoken about today, I appreciate a lot that you brought the resources, constraints, and aspirations forward, and we'll talk more about that next week, so I'll leave that off to the side. But I would definitely encourage you to be thorough, because that at least gives us the framework to talk about what everything should look like, and if we have to make accommodations, then to make those understanding really what has to happen. When you think about the ability of someone to, so we talked about there's an order of protection that's issued, it's violated. In order for it to go from just violation to actually then turn into a criminal matter, even if it's a misdemeanor, how reasonable is that process for the average person to accomplish? And is there anything in any of those practices around statute or practice or policy that needs to streamline the ability of a victim to easily notify, whether that's even if that's remotely or how one does that, and so we don't end up with this scenario where it's harder for them?
a survivor calls 911 on a violation,
Mm-hmm.
and the police do respond, and then the first thing that has to be checked is has the order been served?
Okay.
Because we can only prosecute orders where the offender has been served or has actual knowledge. So if there is no service, there cannot be a violation, which I think is oftentimes we'll see in screening that is an impediment, because we just can't, if you don't know about an order, we can't prosecute you for violating it.
For sure. On that note, do you have any idea the percentage of orders that are once issued that are actually served? Is there a big gap there?
Wouldn't that case management system be so helpful for that? I think
Okay.
it would.
Okay.
And so, no, we do not have access to that.
Okay. Do you have any idea, like from your knowledge?
No.
Okay. So is there any way for a victim to know that an order has been served?
Aside from coming to court on the next, so if an emergency order is issued, there's an automatic 3-week court date. In those 3 weeks, the sheriff is going out and trying to serve the respondent.
Mm-hmm.
At the end of the 3 weeks, then that date is actually for the return of service and for the appearance of the respondent. So they would know at that time. Other than that, I don't know of a way that they would, I'm not certain if they received the short form notification in a shorter time than those 3 weeks. I don't believe so.
Okay. So one of the things for us to potentially consider is how a victim might be aware of the fact that the order was issued. Because one of the things that I think it'll be useful to ask some of the other entities involved, the chief judge, the sheriff, and the clerk of the court, from issue by the court to actually being served, what's the drop-off? What does it look like? How does the victim know that this actually happened so they can plan accordingly? And then what are we doing about ensuring that that's as tight as possible? Okay. So those things are out of your control for right now. And there's nothing about, once they call 911, it becomes an actual crime if someone's violent, if it actually got served. So assuming it got served, then so there's nothing else the victim needs to do in order for a violation to become a known thing and in the system.
Right.
Do you feel like you have the access that you were seeking when it comes to the access to civil issues in order to best prosecute your criminal cases?
Now, yes.
Okay. Is there anything else that you would change about either setting aside anything to do with legislation, with either things that are in the control of the chief judge or practice as far as the ability of your attorneys to best be prepared to prosecute these cases?
I think that would be a technology answer to me.
Okay.
I think that we are still in a position where we are scanning and emailing to the public defender, scanning and emailing to the court. And, part of what the Pretrial Fairness Act did is it created a discovery obligation on the state in every case we're seeking detention on. And so that was a...
Could you explain what that means?
Yes. So if we are, it's the state's job, it's the state's determination if we're going to seek detention. In the event that we're choosing to seek detention, we have to give, by statute, to the defense attorney all of the police reports, the criminal history, any summary of statements by witnesses. And that was something, and that's on a misdemeanor or a felony. And that was something prior to the PFA, that responsibility was not there. So that did add a major lift, particularly for our misdemeanor ASAs, because they were not familiar with doing that, and it's additional time. If we had a way that a system could send those documents automatically, I think that would really cut down on the time that is taken clerically.
Yeah, well, I think I still have my battle scars for getting more computers for the states for the public defender last year, but good. Now I'm glad we have more of that. Maybe we'll do it again this budget time. Okay, one of the things that'd be great to think about as we prepare for your pre-trial or your mid-year budget next year or next week, and then ultimately for the budget, is separating out these threads, which is a lot of times we assume things are statute. They're actually not statute. They're policy that is written by humans that can be unwritten by humans, or it's practice that has just become embedded and it feels more like policy or law. Helping us kind of pull that gum out of the sweater would be really helpful to understand what are the things that we can actually force change on. Because there's lots of things that exist that we just think that's the way they are. But somebody made the rule, and so somebody can unmake the rule. So we want to focus on the things about which we have control. Okay, thank you very much.
Thank you. Thank you, State's Attorney, for being here and for providing more context, I think, around these issues that are very complex. I think for survivors, it's a complicated system. For non-lawyers, it's a complicated system. And for lawyers, it's a complicated system. So there's a lot of nooks and crannies to get lost in. So it sounds like what I've heard over and over again is data management is one of the most at the heart, I guess, of many of the complaints of everybody. So it sounds like that would bring us forward into the 21st century. I think nobody thinks that working off of Excel spreadsheets, each attorney managing their own data is not great because it really contributes to human error. People are really busy in your office. They're doing their best to manage that, but they've got a lot of other work. So how long would it take you to implement a new case management system? It sounds like you guys are working already with the Public Defender's Office and that you have probably done some research. Can you just...
We've met with several purveyors of data management systems, and we have settled on one, and I see Sharon Mitchell back there. We've talked about it, and we are ready to go.
And so how long do you think it would take in order to get through the procurement process at the county and then implement it?
Well, you tell me about the procurement process, but I'll tell you, as soon as you say go, we're ready to go.
Okay, sounds great. Well, it sounds like that would really rectify a lot of things, but once you have a case management system, you'll find a lot of additional gaps, I imagine, with that data, which is great because you can't fill gaps unless you know that they're there. So one of the things that one of the victims here talked about was trying to get more training for domestic violence and mental health support in the family court setting, which I know is not under you. So do you feel like the training that you have in your office is sufficient for domestic violence?
Not yet.
Yeah,
we're starting. Okay. We're starting the process, and my goal is to have this be like getting a master's degree in trial work, and that includes domestic violence. That includes the Felony Trial Division. It includes the Multi-Jurisdiction Bureau. I want our people to be as good at their jobs as they can possibly be, and that's going to be having specialized training for each and every unit.
Great. And so will that be discussed next week in the budget hearing where you'll separate that out and discuss that with us next week? Okay, great. So I guess, and maybe this is a broader issue that you can speak to a little bit. I know that you have data and the clerk of the circuit court has data, the office of the chief has data, and really the office of the clerk of the circuit court really has the external facing view where you can get in the public and kind of see what goes on, who is a civil case, who is a criminal case. Does the public have access to see orders of protection?
So because of our limits on data collection, we have gotten our detention up and running on our website. You can go in there and check on what the detention rates are, who's being detained. The goal is to have that be system-wide, that you should be able to see what's going on a myriad of different things. And that gives us the ability to see, like, oh, we see that and I'm just using this as an example, that it's taking us 2 years to get a rape kit back. Well, that's a logjam in the system, and we can't recognize that logjam as it currently stands. So if there is, for instance, rape kits are not getting processed in a timely fashion, well, once we have that data, we can go to Springfield and say, we need more forensic analysts. We need that logjam to be relieved. So everything is kind of contingent on what we can do with our data.
So I think that what we hear is from some of the victims that have terrible stories. But if there was a lot of information available online that women who are beginning relationships that see some red flags would be able to go online and look up the person and say, oh, well, there seems to be a long history with this person. Maybe I will choose not to have a relationship with them. So it's kind of like, in a way...
It's a push me, pull me, though, because we very much are concerned about making sure everybody gets due process. And we will not be trying cases in the court of public opinion. We are going to try cases in a court of law based on the law and the facts. So if somebody has a pending charge, that information will not be easily accessible. If somebody is convicted of a charge, that's a horse of a different color.
Right. But I think if everything was publicly available after, somebody has gone through felony review and there is a charge and there is a conviction and that is available, I'm just saying, just like we look at preventative health care in our hospital system, and it really prevents some worse things from happening down the road, much like this, if somebody who is a victim would be frustrated at not being able to see their abuser's history. And if they did see that, I think it would really allow, much like that preventative health care helps abate issues further down the line, that might be able to give a little bit more context to people, women and men, who would be able to avoid maybe the situation in the future. So I think if it's convicted, if it's final, that system, in the system, it should be available online. I know that the clerk of the circuit court has a lot of duties and responsibilities in that as well, so we can talk about that when they get up here.
But I'm taking your point in making sure all those victim resources are available on our website. That's not a specific case driven. Those are things that every victim should be able to go on the state's attorney's website and see exactly what's available to them.
Great. Well, thank you very much for your work.
Before we move forward, I just want to let my colleagues know that we have 7 more speakers. So I'm going to hold questions after our state's attorney, after all the speakers speak, unless you all want to start playing practice. Okay. So next on my list is Commissioner Stamps, Commissioner Lowry, Commissioner Britton, and Commissioner Marita.
Yikes, thank you for the gentle admonishment, kinda. But I do understand. I just said something similar to Commissioner Lowry about it. So I'm going to just ask a couple, and if it's okay, is there a way by which we can submit additional questions to you all and get a response back in the interest of time?
You can call me anytime, Tara. You know that.
Tara. Okay.
My daughter is Tara,
Okay.
so that's why I'm having trouble with it.
I know.
Yeah.
That's why I don't mind saying
Yeah.
Tara. I get it. It's the inconsistency of the English language. But that aside, just sitting in this presentation is dizzying to keep up with the amount of information and the if-then situations that are created that comes from perhaps divorce court onto your jurisdiction. And so is there any kind of one-pager or floor chart of something of some sort that can be given to victims that walks them through who's responsible for any part of their situation before they get handed off and it's like, oh no, that's not our department? Because what I heard you say that I didn't realize is that you don't have any jurisdiction over divorce court, but it seems as though much of what we're hearing is born out of that space. And so my first question is about the one pager. The second question, and I'll submit everything else in writing, is is there any intersection between your office and the chief judge's office that come together and say, okay, this is when we're going to share information? This situation was born out of here. I think I may have wrote it better than I'm articulating it, but I just want to know, when does that occur? And in which space, who has the responsibility over, because I heard the GAL, and the issues with the GAL. So it says, if you don't have jurisdiction over the divorce court, where's the intersection or the collaboration with the department that does and then deals with the domestic violence and the divorce piece? Because I'm just really confused as to when something becomes your responsibility and where's the origin story.
If there's a criminal charge, then it's in our wheelhouse. If there's no criminal charge and just a civil order of protection, we have no ability in there to do anything. We do meet with the chief judge's office on a regular basis. We do, talk about things that impact what I do have the ability to do things over, which is domestic violence court.
Okay, I guess my frustration and I won't go into my story, but I have two friends now that are going through divorces, and the number of orders of protections they've had to extend. And she said to me recently, this is why women die. No, we put these in place, and then nothing happens. And then they drag out the divorces. So I'm very concerned about how nothing really happens until something happens, which often ends up in the death or harm of a person who's been crying out for support for a long time. But I was just curious, and anything else I will submit to you in writing. Thank you.
Thank you.
Lowry.
Thank you, Chair. I appreciate it. So I'm going to pose a question to you, State's Attorney Burke, but in truth, this is my question for all of our department heads today. So if during the course of your respective presentations you address this, you won't have to worry about me asking questions. Today is more, let me say it this way, today is not as much about the provision of services. I think instead it's more about the efficacy of the services provided. And I'm very excited to hear about the Special Violence Bureau, but mindful of the case management situation, what I'd like to ask both of you, what's a fair timeline for us to try to discern the efficacy of the Bureau? Because we need to get into a space, and this has been an opportunity, certainly for the 7 years I've served on this board, to not just talk about what we do, but instead also talk about the impact of what we do, and that should be the factor, I think the sole factor, that really leads us relative to resourcing.
So the Special Victims Bureau is, it is not just a way to group cases together. It is a way of we are going to approach prosecutions in this manner for these types of cases. And that is really a basis of just taking people who are the most experienced people in that area, the most experienced people who are advocates in domestic violence and sexual assault and crimes against children, and figuring out what it is that we need to do to make that job go as smoothly as possible for those victims. So can I point to and say, look at this huge decrease? No, but I'm hoping to. That's the ultimate goal, is to be able to show the rates of orders of protection being violated decreasing, the rates of domestic violence decreasing, and the lever that I can pull is the deterrent effect, that you will be prosecuted, that we will ask for detention if you are engaging in that behavior. And that is where we have significantly increased our detentions on domestic violence. We went from less than 50 to at least a 20, 30-point gain on detentions. I'm hopeful that will start to bear some fruit and show those rates starting to drop. But right now, we are still in a house and fire situation.
Thank you.
Commissioner Britton.
Thank you, Chair, and thank you, Madam State's Attorney, not only for the domestic violence commitment that you've made, but also the commitment you've made on hate crimes, which I also very much appreciate. I also appreciate the fact your office has sat down with me to discuss what resources are required. I just think about this anecdotally as I was on trial, it seemed like constantly this past summer. In my other job, I was not the accused. And I was able to use a case management system with my iPad and accessed everything I possibly could need. It is something that is essential, I think, to the fair administration of justice and to make your jobs easier. So that I think we can all commit to. One of the first questions I have is that the more I listen to these things, I certainly understand more of the problems than I see the solutions, because we just keep identifying new ones. I'll give you another one, Madam State's Attorney. You've got the Chicago Police Department, you've got the Sheriff's Office, and you've got every suburban police department in the Cook County area who are going to be administering and enforcing orders of protection. How do you coordinate with dozens and dozens of different law enforcement agencies to make sure it's all being done?
So one of the things that we started doing immediately was making sure that all of our suburban bureau chiefs attended all of they have Northwest Suburban, North Suburban, West Suburban, all of those demographics have meetings on a monthly basis with all police chiefs in that area. So we made sure that each and every bureau chief that was in the suburban districts were going to that. So as we rolled out new policies, we made sure that each and every police department was aware of what our new policies were. They were made aware of what our detention policy was, how we're proceeding on certain types of crimes. And domestic violence is one of those, that we made sure that they knew that we would be asking for detention in a significant amount of these cases when it was possible. So Cook County is enormous. We are bigger than 26 states, which I know shouldn't surprise this county board, but it is an enormous county. And we need to make sure that we are responding to the needs of each and every citizen in that county.
And I appreciate that. I guess my request would be, particularly as it relates to suburban police departments, those of us who have been around a while, we have contacts with those chiefs constantly, and I always try to get their cell phone numbers. So make sure that if there is an issue with any particular suburban police department, that you speak, if necessary, to the Cook County Commissioner that represents that area. We can make those calls as well to make sure those things are happening and doing it in a timely fashion, because it is life and death, and we're going to make sure it gets done. Your Honor, sorry, Madam State's
Go
Attorney.
right ahead. I still like that
title. Old habits die hard. I just feel like there has been some recent activity at the criminal courts where there was a tragic incident where someone was murdered, and there was perhaps not sufficient information communicated, at least from what I've read in the news, about what happened. And I'm not going to talk about that specific case, but as you sit here today with the forms that you have made, do you feel that the state's attorneys have now the resources they need to communicate that to the judges who are making those decisions?
It's better, but are we 100% there? Absolutely not. But we'll get there.
Okay. And when you're using your resources in the courthouses to assist those who are victims of domestic violence, particularly as it relates to a criminal matter, and you're referring them internally, do you also refer them to external groups? Obviously, we coordinate with many religious organizations between the and I'm a part of the Archdiocese's Domestic Violence Outreach Program. There's Shelva in the Jewish community. There's Wings for providing resources for people for residential protection. Do we coordinate with them specifically through the state's attorney's office?
Yes. We have, through our victim witness department, we have a list of over 100 different community-based resources that we refer to on a daily basis.
And my last question is a little bit in the weeds, but I heard people referring to the fact that there are not records being made through court reporters of some of these proceedings. I assume that's more in the, I shouldn't assume. Is that more in the civil side?
It's all in the civil.
That's
the
what I thought.
civil's order of protection, unless you bring in your own court reporter, they will not have a court reported proceeding.
Which is, by the way, in the law division or in the municipal division, it's the same way. If you don't bring a court reporter, there is none there. And I certainly understand the concerns. Certainly a typical victim is not going to get a court reporter to come to their hearing. And I think there are, again, technology issues that we may be able to address those as well. I can tell you that in my most recent trial, there was no court reporter. They used a transcription service using AI. It wasn't very good. So I'm hesitant to say that that's the solution, at least as the technology exists today. But I also know that, I guess my final point, we've learned a lot about the jurisdiction of various entities and how these things work or don't work, and I appreciate that. The Chief Judge's Office, who we work with quite frequently, is not subject to the decision-making power of this board, just as you, as a separately elected, does not have to do what we say. But I think what we do have to say is that we should be able to coordinate amongst these entities in a better way than maybe we have done in the past. And that would include, I would think, a potential domestic violence summit with all of these elected officials and the chief judge and perhaps the chair of the Criminal Justice Committee, if he would be willing to serve on that. Has that happened is my first question.
No, not to my knowledge.
Do you think it would be worthwhile?
Yes, absolutely.
So do I. So I am volunteering The chairman, I'm the chairman of the litigation committee. If you think it's better for me, I'll do it. But I just feel like this is one thing. In fact, I'll do it with you. How about that? Can we do it together? All right. I will pledge to finding a time for us all to sit down if it is acceptable to. I'm not mandating this. I'm just asking if we can all sit down and say, what's the best way forward for us together, including the Public Defender's Office. I think all of that would be worthwhile if you would be agreeable, Madam State's Attorney.
Absolutely.
Thank you.
Commissioner. With that being said, let's thank Commissioner Burke. I'm sorry, Commissioner. Your Honorable State's Attorney, Eileen Burke.
Thank you. Thank you, Chairman Moore. Thank you.
I'm still here, Stan. Commissioner Morita.
Okay, thank you, Chairman. I just had to circle back to when we were talking about the filing and what you're able to do and what you're not able to do and what data we have and what data we don't have. And I cannot underscore the fact enough that we had many people here today saying that they do not get the orders of protection information. They do not know when the orders of protection were served. So we don't need, as much as I love evidence-based medicine and evidence-based anything, I don't think we need to belabor that point that there is a huge problem in the percentage rates of orders of protection not only being filed, but the knowledge that they've been filed and being able to be implemented once a situation happens. So I know that's not under your jurisdiction. So I feel that that is also something if there's said summit or what have even comes from this hearing, which is the purpose of hearing, so that we can have information, gather information, and get deeper data. And this is perfect timing since we're going into budget negotiations. So I just wanted to make that statement that this is not you per se, but we have all these people here who, if we brought them all back up to say, did they know about the order of protection being filed, the answer would probably be no.
You're absolutely right.
Commissioner Morita. Is Commissioner Morita on camera? Commissioner Morita.
Thank you, Chairman, and thank you, State's Attorney Burke and your team for being here today. Thank you to Commissioner Miller for her leadership on this, and thank you to all of the members of the public who came and testified to tell their stories today. I had two, and I'll keep it quick because I think this is a longer conversation for all of us anyways. One, I think thank you to Commissioner Vasquez for bringing up the language access questions. I think over the last few years talking, not just with your staff, State's Attorney Burke, but all of the folks who are involved in the court system is understanding that it's from what I've heard, we provide what is sometimes, half of what the going rate for interpreters are. So we're competing with New York, we're competing with Houston, especially as interpreters are allowed to be virtual more and more. And so I've heard anecdotally that one of the challenges with getting interpreters is the fact that our rate is nearly half of what some of other municipalities and counties are offering across the country. So I would just flag, I know that sometimes in our contract negotiations it's dealt with as a certain level of position, but recognizing, as I think you pointed out yourself, just how essential having qualified interpreters are, and recognizing that as we kind of talk about, what their compensation is to be competitive so that our system can work. So I just wanted to flag that. The second, I guess, is a little bit along the lines of what Commissioner Gaynor and Commissioner Stamps asked, and maybe this is a one-pager also. Just, I hear it was a lot to learn, and I appreciate it. I think my question is, what do you need from us as county commissioners? I know we're going into budget and talking about budget, but also in terms of policy or in terms of even just us as our platforms to be partners. Just trying to navigate through all that was shared. What can we do, and what do you need from us?
We have a significant list that will be an extensive conversation, I think, a week from today. So I am looking forward to working with all of you. I think we all want the same thing. We all want to live in a safe, thriving community, and we're going to get there.
And I know the budget hearings also get long, so I think whatever you can share proactively with us so that we can be prepared to go into those would be helpful.
Great. Thank you.
Commissioner, thank you, State's Attorney. Thank you. Next, we're going to be moving right along. We're going to bring the Chief Presiding Judge, Skaneko Chief Judge's office up to the dais. And also, if you would entertain me just for a second, you can't sneak into my meeting and me not recognize you. I want everyone to join me in welcoming the former city treasurer, the former commissioner of water, the first female secretary of the Department of Transportation, Judge Judy Rice. Give her a round of applause.
It is with the chairman's permission that I'm allowed to stand. I'm recovering from spine surgery, and sitting for long periods of time are not really good for me. But
Apologize.
Thank you so much.
Thank you for.
Is it on?
Yeah, it's on. Is it on?
Hello? Okay. I don't have a favorite song, sorry. Thank you so much for the opportunity to be here this morning. I'm presiding Judge Regina Scanicchio of the Domestic Relations Division. And the invitation and the opportunity to tell you about our guardian ad litem, child representative, and attorney for child program is really very important. So thank you for the time to do so. I also want to give you a little bit of my background. I've spent 36 years of my legal career in the Domestic Relations Division, from a young lawyer to a GAL in the division, a judge sitting over an individual calendar, and now the presiding judge. I took this position in September of 2022, and that gave me an opportunity, and I think we have slides. So if we can get to slide number 2, that would be great. I know that we provided the slides.
Brinsky was supposed to do a slide presentation.
So sorry for the delay. I know it's been a long morning and now afternoon for you as well. I will kind of move ahead. I know that you've heard multiple times this morning that the Domestic Relations Division is a civil division. We hear civil matters that are initiated by dissolution of marriage or parentage actions, along with a variety of other statutory provisions. And we're governed by statute, and we're governed by the Illinois Code of Civil Procedure. We are unique with respect to the types of cases that we hear, because our cases really don't have an end. Once, and I know we've heard that cases go on for a long period of time, even after a judgment is entered, there are post-decree matters. We are the only civil division that has post-decree issues of modification or enforcement when it comes to children. Any luck? Okay. Great. Did he not tell us he was leaving? No. This is the Why, thank you. Okay, I hear that it should be up and running. Just go to slide 3. Oh, domestic relations. So it is labeled Domestic Relations Division, GAL, Child Representative, and Attorney for Child Program. Now I wish I had a karaoke song.
Joe is sharing his screen.
Okay, thank you. So the structure of the Domestic Relations Division. In summary, you can see the chart up there. There are 45 judges in the Domestic Relations Division, including me. We are located at the Daly Center and throughout every suburban district. We are one of the few divisions that has judges sitting in Skokie, Rolling Meadows, Maywood, Bridgeview, and Markham. There are two primary structures in the division: individual calendars or team calendars, and regardless of where a judge is sitting or what type of calendar a judge is presiding over, they hear all types of domestic relations cases. Included, and we've heard this, in our domestic relations cases, there are civil orders of protection that are filed in conjunction with the domestic relations proceedings. I think it's important for this commission to know why GALs and child representatives and attorneys for children are appointed. They are not appointed in every case. They're there, next slide. They're there to assist in determining the best interest of a child. A judge doesn't automatically appoint an attorney to preside in their cases unless there is a conflict, unless there's a controversy, which is also governed by statute in the Supreme Court rules with respect to decision-making or parenting time. These controversies arise. They are complex in nature, and I think it's important for this commission to know that the domestic relations cases, whether it be for a dissolution or a parentage or child support, is much more complex because every issue that comes into someone's life will come into their particular proceeding. And under the Illinois Marriage and Dissolution of Marriage Act, there are 17 factors that need to be considered with respect to the best interest of children. Next slide. So there are three distinct statutory attorney types that are appointed. And these are private attorneys that are appointed to serve with respect to the Domestic Relations Division cases. A guardian ad litem, and I should say that each of these next three slides that we're going to go through are governed by Illinois Supreme Court Rule 907 and the Illinois Marriage and Dissolution of Marriage Act under 5/506. So there are Supreme Court requirements and statutory requirements with respect to a guardian ad litem, a child representative, and an attorney for child. A GAL is the eyes and ears of the court. They are there to investigate. They are there to speak to the children and all parties. They do not have a confidential relationship with anyone in the case. They do not have a confidential relationship with the child or children. They do not have a confidential relationship with the, with the parents. They make written recommendations and report to the court. And with respect to their written recommendations, they are not binding on the court. They are simply a factor in which the court considers in making their ultimate decision. Next slide, child representative. The child representative stands in as an attorney. They have a confidential relationship with the child. They are investigating to take a legal position, a position that is based in fact and evidence that they can utilize for the court to actually put forth a position on behalf of the minor child or children in a case. Again, their position is given to the court, but it is not binding on the court. I think we need to remember these are legal proceedings in which there is testimony and evidence in which the court takes in order to make a decision. Finally, next slide, attorney for child. This is exactly what the title is, an attorney for the child in its truest sense. They are rarely appointed. However, it is the total independent counsel for a child as if they were being represented as an adult. The same confidential relationship, the same advocacy. Moving forward, just so that for the ease of time, I'm just going to use the word GAL program or GAL, but it will encompass both GALs, child representatives, and attorney for children. The development of the program. I came in as the presiding judge in September of 2022, post-pandemic. It gave me a great opportunity to review and revitalize a program that had been in existence for a long period of time, but of course during the pandemic, not much could have been done with respect to the program itself. So we took this opportunity to meet the changes in the law, the judicial process, meet the needs of litigants, and also comply with a Supreme Court Rule 906, which sets forth the qualifications, the educational requirements for these private attorneys, and I keep saying they're private attorneys that are going through this process, who have committed themselves to representing children in these cases, as well as looking at my authority, which comes from Local Rule 13.9, which is administrative with respect to maintaining this court-approved list, as well as modifying or making changes to the requirements of the program. Next slide. So in reorganizing and revitalizing the program, we have developed a steering committee and 5 separate subcommittees, including screening, which is the interviewing and the application process for the GALs, revitalizing the application process itself, which is now a 14-page application that the GAL or prospective attorney needs to fill out before their interview, a significant training process, mentorship, continuing legal education, which also includes the judiciary, as well as a resource committee. And in selecting the steering committee, I took into account seasoned and experienced attorneys who had been part of our GAL and child representative program. I looked at diversity, background, gender, cultural issues, specific needs of children, whether it be within mental health issues. Every attorney comes to our division with a very diverse background. So we have those who have significant background in domestic violence. We have significant issues with respect to mental health or special needs of children, addictions, other abuses, and that is all part of the application process. Next slide. What you're seeing up there is kind of the flow chart of what a prospective attorney needs to go through in order to be put onto this approved list. And it is a application, an interview by a 3-panel group of seasoned attorneys who are part of the interviewing and screening committee. Once they are approved by the screening committee, the information will come to me and I will make the final selection as to the attorney being placed on the approved list. And this process, not every attorney who applied to be a GAL was approved because they did not meet what we consider the minimum qualifications or the experience or the background or the knowledge to represent the most important people in the case, which happen to be the children. Next slide, training. Once the GAL is approved, once the attorney goes through the process that you've just seen, they will be involved in a 2-day training. It's a 2 to 4 panel committee that will do the training for the new appointees. They have an in-depth review of the Illinois Marriage and Dissolution of Marriage Act. They are going through the responsibilities and the role and the ethical considerations of a GAL, the responsibilities that they have to the court and to the families. And they are led by these attorneys who have a significant number of years of experience in family law matters. Next slide. We have ongoing training. So it's not just come in, be approved, and be appointed to the list. We provide additional support, resources for all the newly appointed GALs. And I'm really excited about the fact that we did launch this year the mentorship program, where a new GAL is going to be and has been paired with a seasoned GAL so that they can work together and learn from each other, and as a resource, having the GALs being able to work with someone who's had more experience than they have with respect to new cases. We also provide accredited continuing legal education. So every GAL, everyone on this list, has to complete a required number of seminars per year in order to remain on the list. And what you see up there is just a sampling of some of the topics that we had over the last year. Next slide. Once you are on the list, you are not always on the list. There are requirements to remain on the GAL list. And you need to be a licensed attorney in good standing, maintain your malpractice insurance. You need to complete these continuing legal education seminars. And I think most crucial is that they must take pro bono assignments each year. One new pro bono assignment each year. And I can tell you that many of the attorneys that are part of our program take more than one pro bono assignment each year. There are 167 approved attorneys on this list and thousands of cases. And I wish we had more approved attorneys. I wish we had more resources available to have more attorneys available for our cases. We just don't. And the attorneys must take cases throughout Cook County. So whether it is a child in Markham or a child in the inner city of Chicago or in Bridgeview or in Rolling Meadows, every GAL must take appointments throughout the entire county. Next slide. I know that there are many questions regarding how and why a GAL is appointed in a case. Every family is unique. There is not one case that comes into the Domestic Relations Division that is similar to another case. By gender, by age, by race, by cultural differences, by just the complexity and the unique nature of who we are as human beings, going through one of the most difficult times of someone's life. If you are an individual who is going through a divorce proceeding, if you are an individual who is trying to work through issues with another parent and have a child in common in our parentage cases, these are very, very difficult and emotionally driven proceedings. And because of the unique nature of these cases, you can see this kind of from the list there, what judges, and it's not an exhaustive list, what judges are looking at when they are appointing a guardian ad litem in a case. Again, I have to emphasize, we only have 167 available. We are in an open application process right now, but we have thousands of pending, new proceedings pending, and post-decree matters in the Domestic Relations Division. There's no exhaustive checklist, but what we do have for the judges to consider is a confidential biography that each one of our GALs is required to provide, which will give the judge an opportunity to look up special information, language, culture, special needs of children, addictions, domestic violence, any issues that were going to be pertinent to a case so that the judges can look through the confidential biographies of our GALs in order to find the right fit. Next slide. Financial considerations. I know that you heard information regarding fees or costs. The fees are actually governed by statute, and that is between the court and the parties and the appointed GAL or the appointed attorney. Again, these are private attorneys. So the court works within certain confines to make sure they find the right fit for the family. Supreme Court Rule 298 is a fee waiver. So if the parties or a party qualifies for the fee waiver, it's entered, and they can have a pro bono GAL appointed for them. The fees are waived. The fees are never not waived for child representatives or attorney for children. With respect to financial affidavits, the court has an opportunity to ask each of the parties to provide their financial information so that they can find the right attorney to fit the financial resources of a family. And more often than not, the attorneys on this list are not charging their normal hourly rate. There are attorneys on this list who may, on a private matter, representing a petitioner or respondent, charging $450 to $500 an hour, but for their GAL work, they're reduced. Or they ultimately realize that they're not going to get paid at all, but they still have an ethical obligation to maintain their responsibility to the child that they're representing. Next slide. We also have some great resources when it comes to those who have limited financial resources. We partner with Chicago Volunteer Legal Services, who will accept GAL and child representative appointments, but they are actually supervised by CVLS. So our judges do have those resources available for appointments, as well as the office, next slide, Office of the Public Guardian. Office of the Public Guardian does have criteria which we need to meet. If a judge is seeking to appoint someone from the Office of the Public Guardian, they are not statutorily mandated for the Domestic Relations Division, but they are a resource for us to go to on cases. Next slide. So grievances with respect to your GAL. Litigants have an opportunity to file motions to have their GAL or child representative discharged in a case if the court sees fit. They have an opportunity, if they disagree with the decision of the court, to file an appeal. With respect to the presiding judge's office, it is under Cook County Rule 13.2A and General Administrative Order 15.1, an administrative authority to coordinate and supervise the functions stemming from those rules. The presiding judge's office does not have the ability to govern or interfere with the decision made by a particular judge in a case. I don't have the opportunity or authority to discipline with respect to the judiciary. So those would be the options available if there is a grievance with respect to your GAL. And that concludes, last slide, the presentation with respect to our GAL program. And thank you so much for this opportunity to address you today.
We're going to hold questions until after all the public speakers. Since we have the head of the department, my good friend Draone, please come on up. Welcome to the dais, Draone Mitchell, Public Defender.
Good afternoon. My name is Draone Mitchell Jr., Cook County Public Defender. We are going to have a presentation from our Associate Director of Legislative and External Affairs, Rory McHale.
Thank you, and good morning. Good afternoon, Commissioners. Thank you very much for inviting us here, to Commissioners Miller and Anaya, for your leadership and including us in this conversation, as well as to the rest of the body and all the public speakers we heard from today. Some of the issues that have already been brought up are above and beyond the scope of the Public Defender's Office, but we wanted to add a few comments to this conversation The first of which is that the Law Office of the Cook County Public Defender is committed to collaborating with the other stakeholders in our system to ensure true public safety, and that our core mission every day is about ensuring access to justice for each of the county residents that we represent. So in our work day to day across Cook County, the Public Defender's Office represents survivors of domestic violence, of gender-based violence, and of sexual assault. Not only true among our cases in the domestic violence courts, but across all of our units and divisions. Without a doubt, this is a theme that is present in the lives of many individuals that we represent. And I wanted to thank Commissioner McCaskill, who spoke to the interconnectedness of where the traumas and the harms in one system can translate into others, because it is that same set of instabilities we see that comes into schools, that comes into housing, that pushes folks into the criminal legal system when there are instabilities created. And the violence and misconduct that can take place between family members, in intimate relationships and across domestic relations, that comprehensively affects the lives and the communities of the individuals that we represent. That is true in finances, in custody of and access to children, in housing stability and access to housing. These ripple forward, and we find interconnected in individuals we are representing in matters far outside of the systems that we're discussing today. As we discuss moving forward with changes that can ensure increased justice and access to justice for county residents, the other stakeholders you've heard from and will hear from today know that the Law Office is committed with open arms to working together and collaborating on this change without at all sacrificing our core mission of vigorously representing every individual that we are honored and lucky enough to have as a client. One recent example that has taken place in a change in systems between the previous June of 2023 meeting of this committee and today is that the Pretrial Fairness Act has gone into effect. That is an act and a piece of legislation in Springfield that involved the collaboration and the working together of many different advocates and stakeholders in the system. And it is one that has affected the core information we're discussing here today. The Pretrial Fairness Act ended the money bond system that had punished poverty and elevated wealth as an ability to affect one's custodial status pre-trial. It also had replaced a system that enabled a lot of uncertainty for individuals who were incarcerated pre-trial as to whether that custodial status would change during the course of a case based upon one's ability to pay for a way to exit custody. Instead, the Pretrial Fairness Act ensured a comprehensive pretrial custody hearing would take place so that judges, rather than individual law enforcement officers, would be the ones making decisions over custodial status, and created mandatory notice and communication requirements between the state and the survivors and the victims in individual cases. We were happy to work together with other stakeholders on that matter. We are very appreciative and honored of the opportunity to be present with you all here today. And we look forward to collaborating not just with the board, but with the other members of the Cook County Justice System on any changes and opportunities to work together.
Jason Hernandez, please come on up. From Cook County Sheriff's Office. Circuit Court.
No problem. Good afternoon, Chairman, members of the County Board. My name is Jason Hernandez. I am the Executive Director for Intergovernmental Relations here at the Cook County Sheriff's Office. I am joined by my colleague, Joseph Bellatier. He is Executive Director who oversees court services. And before I go into my presentation, and I'll try to keep it brief, I know there's other speakers, I want to take a moment to acknowledge this board's work in advocacy for survivors of gender-based violence. More specifically, Commissioner Miller, who always answers the call and makes the call and is a tireless advocate for her constituents in her district, but all throughout the county. Same goes for Commissioner Anaya, who has never wasted an opportunity to embed herself into our operations to see firsthand what it's like to do this important work, to go out in the community and attempt to serve an order of protection, to see through the eyes of a survivor what it's like to navigate what can at times be a very confusing court system, and to just get the perspective of our agency and just be a sounding board for us to give ideas on how we can make this better. So thank you all to the board and for everyone's efforts. On behalf of Sheriff Dart, we're grateful to have the space, and of course, Chairman, for providing the space to be part of this conversation, and by giving us the opportunity to lift up the important work that's taking place every day in our agency, and to reaffirm Sheriff Dart's commitment to support survivors of gender-based violence. See a lot of familiar faces out in this room. A lot of them have contacted our office for support at a time when they need it most, trying to make sense of the senseless, and your stories in navigating this complex system is inspiring. And I know we've had a lot of conversations over the months and years about how we can find something that resembles a resolution in your cases. But just thank you for sharing your stories, which are complex and multi-layered and very, very unique to the circumstances you're experiencing at home or in your community. So thank you. The sheriff has sought to transform the sheriff's office into a national leader around how law enforcement can best advocate for and protect survivors, as well as how to provide that real critical linkage to services when a survivor may need it, and like when they need it the most. And as you've heard today from public comment, there's not enough. These linkages that the sheriff seeks to provide through his staff and that he's assembled, there's never enough. There's not enough housing. There's not enough shelter capacity. We seek to provide support on everything from transportation to connecting to substance abuse to mental health support to something as simple as transportation to and from court. And there's just never enough. So we're happy to be part of this conversation about how we can explore bringing more of those resources to the county. But the programs and the services and the operational enhancements that Sheriff Dart has put into place, we're proud to say are now the gold standard, and we hope that every other law enforcement agency across the country can, observe what we're doing in our office and put it into place. And at the heart of all of that work around addressing gender-based violence is a simple yet essential principle, and it's that we seek to do no harm. And that's a reoccurring theme today in our remarks, is that we seek to do no harm. So every operational enhancement, every innovation that we seek to put into place at the sheriff's office, we always stop and take a breath and say, let's run this by the advocates. Let's run this by the survivors. Let's take into account their perspective and unique ideas about how this, something that might seek to do some good, is more complicated than we might think. So that relationship with the advocacy community is so critical. And it informs every decision, every innovation, every reform that we have at the office. So our mission is not only to enforce laws, but to protect dignity, restore safety, and of course, empower survivors. And the sheriff has been very clear. We're not here to simply process cases. We're here to stand with survivors and to meet their needs and to remove the systemic barriers that far too often compound their trauma and create barriers. It's really, really important work. And it's personal for our staff. Our officers are those that are the first to arrive at the scene of a terrible domestic incident. We observe what children are trying to process in those complex traumas on the scene, all while trying to effectuate an arrest and create trust in the communities that we serve. So we'll never stop in our pursuit of justice and for trying our best to provide those resources to those who need it the most. So, Tiffany, you want to start with the first slide? Great. I'll highlight some of the work that embodies this trauma-informed and very survivor-centered approach. I'd like to start with court services. So he's made a number of enhancements, the sheriff, established new programs around modernizing these systems that we utilize to serve an order of protection. After working closely with the members of this board and the Office of the Chief Judge, we are pleased to report that the after-hours Court of Protection program is operational, and our collaborative approach has successfully expanded access to the courts outside of traditional business hours. That was no small undertaking, but our collaboration with the other justice system stakeholders was critical to getting that off the ground, and of course for our commissioners on this board for keeping the conversation going. Last year, Sheriff Dart also successfully launched a domestic violence liaisons team made up of support staff that work to notify a petitioner when an order of protection has been served, help provide a linkage to services, and create, in some cases, a personalized safety plan. And in some other instances, determine if another unit within the sheriff's office or another law enforcement agency needs to be made aware regarding the nature of any known threats. All of our agencies' domestic violence liaisons have lived experience with domestic violence and a minimum of 40 hours of training in domestic violence advocacy, crisis intervention, and trauma-informed care. We currently have 5 domestic violence liaisons and 3 licensed clinicians that support petitioners at our courthouses. The Sheriff's Office has also established a survival portal system to assist petitioners with navigating the system and to enhance communication within our civil process unit. It is opt-in, and we are working on getting to a system where with opt-in, we can provide timely text messages or emails to survivors about when an order has been served. Again, none of those decisions are made until we've had the opportunity to receive feedback from the advocates that work so closely with our office and do so much great work out in the community. Another new initiative that we're proud to announce is what we've come to know as a grid system within the civil process unit, and that's really transformed our ability to get an order of protection assignment out once it's been entered into our leads to all the available units in a particular geographic area, so that any sworn member of our staff, including sheriff's police, can issue a short form notification. This streamlining has really allowed us to do our best to expedite service delivery. And just to give you some perspective, our teams on average attempt to serve between 250 to 300 unique orders of protection a day, oftentimes multiple attempts on one particular order. So it is very, very complicated work. We have approximately, and if I'm wrong here, we have approximately 75 deputies assigned to serve orders of protection, and we'd like to see a lot more. Finally, in many instances, our agency's ability to successfully serve an order depends on the strength and the accuracy of the information that is presented by the petitioner when they're in court. It's a major challenge at times because in some cases a survivor might not have had contact with someone. It might have been electronically. They might not have a last known address or contact information. And we certainly have analysts on staff that attempt to identify and find individuals to serve orders. But we're always looking for ways to make that process more robust. We have something called a confidential information sheet, which is how that information is shared, and we're seeking to digitize that process and to allow petitioners the opportunity to continuously update our office electronically as new information becomes available. Now, our domestic violence liaisons are keenly aware that some survivors may be apprehensive about possessing anything that could tip off their abusers, and that's why our teams are taking steps to work with the advocates on devising a system that's confidential, discreet, and capable of being erased with the swipe of a finger. So it's a really important initiative that we're happy to get off the ground. Next slide. As this board is aware, the Illinois General Assembly this year passed an important piece of legislation known as Karina's Law. Sheriff Dart was proud to have championed this legislation and worked closely with the advocates and our allies in Springfield on ensuring passage. It provides law enforcement with the authority to execute a search warrant to promptly seize firearms from the possession of a respondent who are subject to an order of protection. There was a lot of communication and coordination with our partners in Cook County system, and we're proud of that. It's a landmark law, and we've been in very close collaboration. So we're going to continue to refine and work to ensure proper and safe implementation. Next slide. Finally, the sheriff understands that in order for our employees to truly serve those who have been impacted by domestic violence, harassment, stalking, intimidation, it's going to require a culture shift within our agency and all agencies. That includes working with our partners out in the community, expanding internal training, advocating for improvements to the system, both internally and externally. And here, I'm not going to read them all, but you can see some of the initiatives that have been put into place to make sure that our staff on the front lines really have the best training and understanding of what survivors are experiencing out in the community. And all this work really underscores one critical truth, and that's that survivors are not case numbers. They are human beings with voices that deserve to be heard, safety that deserves to be protected, and healing that must be supported. So we don't just respond to violence, we disrupt cycles of harm in the sheriff's office. We restore agency to those who have had it stripped away, and we place survivors, not the system, at the center of every decision we make here at the sheriff's office. His vision for the work is bold, but it's grounded in compassion and accountability. And the sheriff has insisted that our office be a place of refuge for survivors, not a source of fear and confusion. That means prioritizing accessibility, transparency, equity, and above all, humanity. So grateful for the opportunity to be here today, Chairman. Members of the board, we know there's more work to do, and we welcome the board's attention and continued partnership. Thank you very much.
Thank you, Director. Please have either you or staff stick around for questions later. Thank you. Moving right along, I'd like to call the Honorable Judge Judy Rice and Judge Katie Nolan to come up to the dais and talk to us about this. Thank you.
Good afternoon now, everyone. I want to thank Chairman Moore for chairing this meeting, and I also want to thank Commissioner Miller, Commissioner Anaya, Commissioner Degnan for all of their hard work in the area of domestic violence. Each of these commissioners have come to our agency, has come to our courthouse and brought their staff, and I really appreciate the collaborative nature and collaborative work that we're doing together. I also want to say thank you to the survivors who testified. I know that has to be very hard, and I want you to know that it has been a learning experience for us. We hear what you're saying. We know some of the things that we have to improve on. We have done a lot of work in domestic violence court over the last few years, but it's not over. There's always more that we can do. So I want to get started with some of the slides that we have. The first slide talks a little bit about our organization and structure. I want to move to a point at the bottom of this slide. According to all of our statistics, we have seen over the last 10 years a 42% increase in domestic violence cases. Since I first started coming to the building as a judge in 2015, our cases have increased that much. We're taking in about 1,200 new civil orders of protection every month. If you come to 555 West Harrison, you will find any given day about 100 people in our lobby seeking to file civil orders of protection. We handle over 20,000 cases, both criminal and civil, in our division. We have created a centralized location for domestic violence victims, and that centralized location is at 555 West Harrison. And I also want to thank some of our partners at that location that are here today. We have our advocacy community representatives from the network, Ascend Justice, Legal Aid Chicago, Legal Aid Society, and Lifespan. And we would not be able to do what we do without them being there. The hard part about what we do is that 90% of our victims come to our courthouse alone. They have no attorney. Sometimes they have no advocate. they have no family member. And so we have to support someone who's coming to our courthouse alone. And every time we try to make it a little bit easier in terms of what they have to write out, it gets worse. A victim has to fill out a 36-page petition in a civil case in order to get that case initiated. So I'll talk a little bit more about that. Our courthouse, have 9 courtrooms in our courthouse. We're divided between criminal cases. We have 4 criminal courtrooms and civil cases, 4 civil courtrooms. And we have 1 first appearance courtroom. We are finding, since the implementation of the Pretrial Fairness Act, that we have to have way more than 1 first appearance courtroom. And I'll talk to you a little bit more about that. We have 16 judges assigned to 555 West Harrison. And we have a judge that does domestic violence in each of our 6 suburban districts. Each of these 16 judges are receiving more and more training, and that's something that we've been working on over the years, is getting them more and more trained in the cycle of violence and things that they need to understand to rule on the cases that they have. If you recall, in 2021, Chief Judge Tim Evans put together a committee, a blue ribbon committee, to study domestic violence. Commissioner Anaya, I know that you were a member of that committee, and that committee made recommendations that came out in 2022. I don't like recommendations that sit on a book and a shelf. Those are recommendations that are work that we have to do to implement, but we know that that's not where it stops. We want to continue to get new recommendations to try to improve the services that we provide victims. Are we moving through the slides? Yeah. Okay. All right. So I want to talk about some of the programs that we've implemented. One of the recommendations was that we hire litigant services associates to help victims where there may not be enough advocates there. When they come to 555, they come into an intake room that's a help desk. And so we have 3 litigant services associates. We have some that are fluent in Spanish as well, to help people to sit down and write out their petitions. We have a child relief expediter program that we've created. And I'm proud to say that...
Use a pen here, sign and print.
Please mute yourself if you're on Teams.
Thank you.
And I'm proud to say that the Office of Violence Against Women will be here from the federal government on Thursday because this program has received such success that they want to see this program rolled out in 2 other states, state of Delaware and the state of Utah. And so we are going to be training the officials from those states on our Child Relief Expediter program. And what that program does is if people have children in common and they have domestic violence in the home, they're going to need to oftentimes co-parent. So that program helps to negotiate what that parenting looks like and whether it has to be supervised parenting time. Unfortunately, in Cook County, we only have 6 child exchange sites for supervised parenting. So that's a need that we're going to be asking for as well. We have created a hearing room on the first floor so that litigants don't have to go up into the building to see a judge. Once they file their petition, they can walk over into our hearing room L1 and they can see a judge and get an emergency order of protection. So what we're trying to do with that is shorten the time frame that it takes someone to get an order. Sometimes people stay in our building for 3-4 hours, seeing the state's attorney, filling out their paperwork. And so if we can condense that time frame even more, that's what we're trying to do. We have interpreter services available in all cases, and we are focused on hiring bilingual or multilingual staff. For example, our senior attorney, Renata Steele here, speaks Russian. And so we tap into all of our employees and what languages they speak, the culture they come from, to help us engage with our victims. Our stalking no contact cases. We were getting overwhelmed with the volume of hearings with those cases, so we have worked on an agreement with First Municipal Division that once those cases are ready for trial, we send those out to the First Municipal Division. We have a partnership with Domestic Relations because, as you know, by local rule, If they file for an order of protection in domestic violence court, that we have to transfer that case to domestic relations court if there is a domestic relations case pending. And that is done for the convenience of the victim, so they don't have to keep coming back to 2 or 3 courthouses to see a judge. We have provided Zoom booths. We are operating a lot of what we do remotely. And so sometimes people do not have Zoom, and when they come into the courthouse, we can Zoom them over to domestic relations court. We can Zoom them to any other courthouse that they may need to go to in Cook County. And we can Zoom them up to a judge who can hear their case. So we have judges sitting in their chambers because we do not have enough courtrooms. It's hard to believe it, but in 25 years, we have outgrown the building that was built for us. And we do not have enough courtrooms to handle the volume. We created a mental health diversion call. We have a judge that her whole call in the afternoons is with people who have mental health issues. We have some family members that come in. They might have a older child that lives with them that has a mental health issue, and they become violent with that mental health issue. That family does not want to see that person arrested or jailed. They want to see them get help and services that they need. And so we have a mental health diversion call. So if that person follows all the recommendation, the mental health professionals and the judge, at the end of the day, they are not prosecuted. They are receiving the medicine or the hospitalization that they need. We are training our judges. We are training our judges to understand the cycle of violence. We are trying to have them go through at least 2 trainings a year so they understand the cycle of violence, and they also understand the factors that can create lethality. For example, we're teaching judges, if you hear things like threats with a weapon, pictures being sent of a weapon, strangulation. So some of these things are indicators that this may be a lethal situation. Our ongoing efforts, we're collaborating with the clerks, MIS department, to get more information out on the caseloads that we have. We've asked for the chief judge for more judges to do additional rotations. We are doing 3 rotations of judges in domestic violence court now. We have a judge that has their regular court call, and they handle their regular court call. We then have judges that stay late in the afternoon. We call it late duty. And they stay for anyone who's come to our building by 4:30 to fill out an order of protection, and they help them until they leave. So we have judges in our courthouse from 7:30 to 8 o'clock doing late duty. We also have an after-hours program where we have judges every night from 9 p.m. to 3 a.m. doing orders of protection, and on the weekends from 1 p.m. to 5 p.m. I'm a little tired this morning because I did the after-hours duty last night, and it is just kind of amazing to see the things that we see in the after-hours program. For example, we had one judge who was doing a hearing, and after hours, a young woman said her boyfriend is stalking her, harassing her, continuing to bother her. And just as the judge was about to rule on that hearing, she hears banging in the background and threats being made to this victim. It's the boyfriend coming at midnight, banging on her window, banging on her door. So what did we have to do? We had to get on the phone to the police department to do a well-being check for this victim. So we are doing that every night of the week. In fact, we've asked for 5 more judges so that we can have these rotations happen and not have our judges be too tired to hear these cases. Technical improvements. We are making technical improvements at our help desk to get more information from victims as they come in. Do you have children in common? Is this the first time that there's ever been a domestic violence situation between you? Does he or she have weapons in the home? So all that information, our MIS department is creating a help desk database for us to be able to log people in real time and put that information down. A couple of other things that we've implemented recently is the Safety Act. We all know about that. It's one of the biggest changes in the state of Illinois is that we no longer have cash bail for individuals. And our judges have to decide whether that person is released, detained, or released with conditions such as GPS or EM. We have made some changes there, and I appreciate hearing from State's Attorney Burke because she's made some changes for us. Domestic violence used to be a first stop for assistant state's attorneys, and we told her that can't be the case. We have to have experienced state's attorneys in those rooms because these cases are life and death cases. And so now she is putting more highly trained, more experienced state's attorneys in those rooms. We also had to have more training and time for our judges. We were trying to do those hearings at first in the 10 minutes to 15 minutes it would take to do a bond hearing. We can no longer do that. Those hearings are going on for sometimes 40 minutes to an hour because we want to make sure our judges get all the information they need to make a decision about whether this person should be detained or whether they should be released. Karina's Law. You've heard about Karina's Law. This is a big change for us because we know that in implementing this law, we're hoping that we can save more lives. You heard about the murders that happened last year. In 12 of those cases, those victims were our clients. And I want everyone to know that our judges feel such compassion for them and their families because it's hard for us when we see a person one day, we give them an order of protection, the tool that they need, and then we learn a day later that they've been killed. So we are training our judges more and more about indicators of lethality. One of the things we know in the work that we do is the most risky time for a victim is when they're trying to leave a domestic violence relationship. And when they say it's over, I'm gone, that is a very dangerous time for them. And we know that if there are guns in the home, not even whether they've been brandished at that victim, the mere fact that there are guns in the home can be a lethal situation for a domestic violence victim. And so our goal in Karina's Law is to issue warrants to check box 14.5 on the statute to try to get guns out of the hands of people who have abused their partners. And I want to say that even though we have a very, Supreme Court that we did not think was going to rule this way, but the Supreme Court of the U.S. ruled that in the Rahimi case, that anybody who has guns and is an abuser should not be able to have a firearm and should not possess a firearm in their home. We've done about 45 warrants under Karina's Law, and the police department, we're collaborating with the police department and the sheriff's office, and it's hard to believe what they've pulled out of homes already. Guns, crossbows, knives, all types of weapons of violence that victim could have been subject to. So with that, we still have a lot to do. One of the pilot programs that we started just this last week with all of our partners is that we are actually trying to get more attorney help with victims up into the courtroom. So instead of spending time helping them to write up petitions, our attorneys that work with us are actually going into court with victims, helping them to argue their cases, to get emergency orders of protection, and trying to get more representation for them. But that's the help we need, is all the services that we have in our building, we can double and triple them because for the most part, women, men who come to file these cases file them alone and face them alone. So with that, I hope we have questions.
We're going to take questions at the end.
Okay.
So you can just stick around just a little bit more.
All right.
Almost done. Okay. Mike, let's bring to the dais the clerk of the court, Doris Goodwin and Renee Banks.
Chair, if I could call a committee.
Oh, I'm sorry. First, we're going to have Bill Lowry call for Health and Hospitals.
Thank you, Chair. With the hour having reached 1 p.m., I'd like to call to order the meeting of the Cook County Health and Hospitals Committee.
Thank you, Chairman. Commissioner Aguilar.
Here.
Vice Chair Anaya.
Mr. President.
Commissioner Britton. Commissioner Daly. Commissioner Degnan. Commissioner Gaynor. Commissioner McCaskill. Commissioner Miller. Commissioner Moore.
Present.
Commissioner Morita. Commissioner Morita. I'll add her when she joins. Commissioner Kevin Morrison is absent. Commissioner Sean Morrison. Commissioner Scott. Commissioner Scott. I'll add him when he joins. Commissioner Stamps. Commissioner Trevor.
Trevor here.
Commissioner Vasquez.
Yeah.
Mr. Chairman is present.
Present.
A few members did not respond. We will revisit this when you resume, and you might have 2 remote participants.
Should I take such a motion before I recess?
Can you wait till we return? They may
You
not
might hopefully
be
All right,
connected
I'll do
then.
so.
better have a quorum.
All right, I'll now recess the Cook County Health and Hospitals Committee meeting until the call of the chair.
And there was a quorum. Thank you.
Commissioner Gaynor.
Madam Secretary, I believe that we wanted to go quickly through the
Madam Chair, I believe they wanted you to go quickly right at the end, and you still have another 3 presenters. Yeah, so if you can just hold tight. As soon as they're done, we're going to run through your first 2 committees, and then you need to make an announcement for the time that pension will meet tomorrow. So just a few more minutes, please. Thank you.
Good afternoon. Good afternoon, Chairman Moore, Vice Chairwoman Stamps, and members of the committee. My name is Doris Goodwin. I am the Associate Clerk of the Criminal Bureau for the Clerk of the Circuit Court, Office of Mariana T. Sparopoulos. I am responsible for the Domestic Violence Division, and I am here with the Executive Clerk of Court Operations, Renee Banks, and Intergovernmental Affairs Officer, Delio Calzolari. Thank you for the opportunity to speak today about the efforts of the Office of the Clerk of the Circuit Court to strengthen protections and improve services for survivors of domestic violence. And special thanks to Commissioner Miller for her resolution calling for this hearing. Today I'm going to talk about the steps the Office of the Clerk of the Circuit Court has taken to implement provisions of Karina's Law, the Domestic Violence Survivor Center, Domestic Violence After Hours Court, stronger protections around confidentiality, and partnerships with legal aid providers. Clerk Sparopoulos' office has taken deliberate and comprehensive steps to meet not only the legal requirements of Karina's Law, but also the moral responsibility to ensure that survivors are treated with care, dignity, and urgency. One significant accomplishment has been the establishment of the Domestic Violence Center, Survivor Center in Markham. This space is designed to provide trauma-informed support in a confidential, safe, and resource-rich environment. The center offers survivors direct access to court services, advocacy, and assistance, thereby minimizing re-traumatization during what is often one of the most challenging times in their lives. It is staffed with three clerk's office employees who assist with the filing of emergencies of orders protections, stalking no-contact orders, and civil no-contact orders. The center includes a children's room, 2 private screening rooms for confidential meetings between survivors and advocates, and a safe, welcoming waiting area designed to reduce stress and provide a sense of support and security. Recognizing the urgent and time-sensitive nature of domestic violence situations, we have partnered with judicial leadership to launch an after-hours domestic violence court. This initiative enables survivors to obtain emergency orders of protection outside of traditional court hours, ensuring justice is accessible when it is most urgently needed. Understanding that protection can't wait until morning, our office was committed to make this pilot program successful. We dedicated a permanent court clerk and manager to this effort, ensuring consistency, reliability, and expertise. This demonstrates our long-term commitment to accessibility and survivor safety. And I want to point out that the hours of the domestic violence after hours court is Monday through Friday, 9 p.m. to 3 a.m., and Saturday and Sunday, 1 p.m. to 6 p.m. So it is a court operation that runs 7 days a week. We have strengthened confidentiality and document protection protocols in alignment with recent legislative changes. We have implemented stricter restrictions on sensitive documents to prevent unauthorized access and ensure the confidentiality of survivors. This includes reinforced sealing procedures, limited access controls, and ongoing staff training on the handling of protected case information. This not only meets legal requirements, but also reinforces the trust survivors place in our system to protect their most private experiences. In direct response to Karina's Law, our office initiated a system-wide evaluation and overhaul of our internal processes. We enhanced intake protocols, developed a case flagging system, created clear communication pathways among court personnel, stakeholders, and justice partners to ensure that critical case information is recognized and acted upon quickly. In collaboration with our justice partners, including judges, prosecutors, law enforcement, and advocates, we also participated in the creation of new court forms, case management codes, and newly engineered record-keeping protocols to fully support the law's implementation. The office has worked diligently to ensure that created coding would be effective and enable clear and concise record-keeping. As part of that system-wide approach, we trained and refreshed all of our court clerk staff across the office to ensure consistent customer/survivor-centered service. Finally, we understand that process alone is not enough. People need support. We have strengthened our collaboration with legal aid providers and advocacy groups to provide wraparound assistance. We've also prioritized accessibility by offering multilingual services and building inclusive digital platforms that allow all residents of Cook County to navigate the court system with confidence. In summary, Clerk Mariana Sparopoulos and her team is not just responding, we're leading. From form creation to staffing models, from physical spaces to digital tools, we are building a survivor-centered model of justice that prioritizes compassion, accountability, and access. Thank you for your time today. We remain committed to this work and open to partnership and dialogue as we continue building a system that truly serves and protects. Thank you.
All right, do we have Sarah Hawkins? Is she here? Sarah? There she is. Come on up. Sarah Hawkins with the Public Guardian's Office. Please welcome her to the board. Thank you for waiting.
Thank you.
So patient.
Thank you.
Before you begin, a bit of housekeeping. Please welcome to the board Calumet City Alderman Renee Wilson. Give her a round of applause. Thank you.
Okay. Good afternoon. I am Sarah Hawkins, the Director of the Public Guardian's Domestic Relations Division. And today, I appear on behalf of the Public Guardian, Charles Goldberg. First and foremost, I'd like to thank the commissioners for the opportunity to testify in this hearing today about implementing safeguards to ensure that both the victims of domestic violence and their children are protected. By way of background, let me tell you a little bit about the Public Guardian's Domestic Relations Division. Currently, we provide representation to more than 800 children in highly contested custody and visitation disputes. All of our cases are by court appointment, and they are concentrated in the divorce and parentage courts, primarily at the Daly Center and Markham Courthouse. As a result, during the pandemic, because we've been able to do virtual court, we've been able to take appointments also from some of the suburban branches. So we've been able to expand our reach as child advocates in those courthouses. In addition, in our juvenile division, we represent about 6,000 children in abuse and neglect cases in juvenile court. Understanding that the impact of domestic violence is extensive and is a complicated and multifaceted issue that affects communities and families, the Public Guardian supports implementation of safeguards for the protection of domestic violence and gender-based violence survivors and understands the critical importance of ensuring that the safety and well-being of child victims are also protected during this court process. In the Domestic Relations Division in the Cook County Public Guardian's Office, we have unique expertise in representing children and handling complex issues surrounding domestic violence. And just a little bit about the expertise that we have. Many of the attorneys that work in this division have had years and years of experience where they've worked in child protection court, they've had years of training, and they've had years of litigation experience. And so we do have unique expertise in representing these children. At this time, our caseloads are currently about 50% higher than the ethical caseload standards established by the nonpartisan governmental and academic research. To effectively represent children in domestic violence court, should we be allowed to do that, it would be critical that we be provided with the appropriate resources. Should our role be expanded to domestic violence court, we see our representation stemming beyond the basics of advocating whether the child should be a protected party in an order protection petition. One of the things that you should understand about our advocacy is we just don't appear in court. Part of our role as an advocate for children in these type of proceedings is that we also advocate on behalf of the children in terms of securing services, not only for the children, but for the entire family. Some of those services includes the needs for mental health services, mental health evaluations, domestic violence treatment, appropriate parenting services, and supervised parenting time resources. One of the things that we've been hearing today is the fact that some of the cases go on for a significant period of time. One of the reasons that we find in terms of the cases having a lengthy history is that we often have some difficulty finding services for not only our clients, but services for the entire family. The services and resources are few. And so that has been problematic for us. However, should we be allowed to take on this role in domestic violence court, we believe that that would be part of our role as child advocates to help locate those services and make those referrals for the families as well. In conclusion, we believe that our advocacy as child representatives from the Public Guardian's Office, we believe that our advocacy would serve in the best interest of these children in court. And again, I'd like to thank you for the opportunity to participate in these important proceedings. And I know that the Public Guardian also would like to extend his thanks on behalf of the opportunity to present to this body today.
Thank you so much. Now we're going to take questions from the commissioners for any of the prospective speakers. Let's start with Commissioner Anaya.
Thank you, Chair. I'm going to be brief with my questions. I will ask every department that presented if the person that presented is the best contact, so we can forward any additional questions. But really quickly, just for the Chief Judge's office, I was a part of the 2022 Committee on Domestic Violence that was started again in 2011. The recommendations came forward in June. I just want to know how many of the recommendations that were presented were actually implemented, and then what the time frame looks like specifically for the publication and release of data for domestic violence courts. So that for the Chief Judge's office, and I'll have the same question for the Clerk's office in regards to the releasing and publishing data on domestic violence cases.
All right. Next, I have Commissioner Bridget Degnan.
Sorry, are they able to address that really quickly?
Oh, you want him to address
Yeah, and then I'll ask the other questions in writing. That was for the Chief Judges and then the Clerk's office.
Somebody from the Chief Judge's office, go to the microphone, please. Yeah, please. Just give us one moment. Yeah, you can come up here if you like.
And then my final question that I'm going to ask today is going to be for the Public Guardian. I know we just had a great presentation. I'm going to want to
Bring the
know.
public guardian back up.
Yeah, I'm going to want to know if we heard today a lot of cases that the child oftentimes are put in situations where they still have access or custody with potentially a parent that is violent, and I'm just wondering what the public guardian is doing in that regard in advocacy.
So to help with time, why don't we bring somebody from the sheriff's office, bring them up here?
Yeah, and just
and also somebody from public defender's office, come up here. Someone from the chief judge's office, come up here. Thank you.
Commissioner, to answer your first question, Commissioner Naya, the contact person for domestic violence division would be myself or our senior attorney, Renata Steele.
Okay.
We can provide you with the information.
Perfect, thank you.
And with regard to the final recommendations of the committee, we implemented 10 of the recommendations of the committee.
And those were the ones on the slide, correct?
Right, those were the ones on
and then the
slide.
ongoing ones, are there any that are not started, basically, from the recommendations?
The one recommendation that we have not found a way to implement successfully is getting child support done in domestic violence court.
Okay.
And that's because, as you know, child support primarily happens in domestic relations court. The state's attorneys are all assigned over there. All of the bells and whistles tools that are needed to calculate child support reside more so in domestic relations. But we know that that's something that we have to address in a different way, getting child support done out of domestic violence court.
Perfect. Thank you.
Because, one of the reasons that oftentimes people cannot leave a domestic violence situation is because they can't afford to parent a child on their own.
Perfect, thank you. And then the other question that was for the clerk's office and the chief judge is in regards to publicizing data regarding domestic violence cases.
Yes, so my name is Kate Nolan.
Can you make sure you put the mic down?
Thank you. Kate Nolan, Director of Legal Research for the Office of the Chief Judge. And we are working with our partners we share the goal of having the data dashboard. We participated in other public-facing data dashboards, the Pretrial Fairness Act dashboard. We have our EM dashboard. So we do want to publish that. We're working with our partners to make that happen. I don't have a definitive timeline to share with you, but we can get back to you about that.
Would you be the contact person to
I
follow
would
up?
be.
Okay, thank
Yes.
you. And I don't know if there's anyone from the clerk's office that has.
From the clerk's office, please.
Can I address that really quickly?
So currently, we just, a few months ago, we established on our website a data dashboard, which includes the data entry, which includes the domestic violence numbers. But for a complete overview or numbers for the domestic violence, that would be a request that we would get. It would not be publicly released at this time. Right now, we're under the judges, whatever the judge directs us to do as far as sharing our data for criminal. They're the ones who direct us
Okay.
to that.
Thank you.
On
My
that
final
topic.
question.
Okay.
Sorry, my final question was regarding the public guardian on advocacy when children are still have access to potentially a parent that is violent.
First of all, thank you, Commissioner Anaya, for that question. When children are exposed to domestic violence and when we have cases that have domestic violence issues, we make sure that both parties are assessed for services. So if there's a person who has been a perpetrator, we make sure that they're assessed for services and perhaps that they engage in some sort of domestic violence treatment. We also advocate for domestic violence services for the survivors as well. But more importantly, we want to make sure that our clients, who are the children in these cases, also have some sort of individual therapy to address the trauma that they have received as a part of being in a domestic violence situation within their family. We also make use of the other resources that are out there for us. So, for example, if we're concerned about domestic violence, we take advantage of the safe exchange programs. There's also supervised visitation if it's appropriate. But we want to make sure that both the victims and survivors, if you will, of domestic violence have the appropriate services and as well as the perpetrators of domestic violence. We make sure that they have those services as well. So we see that as part of our advocacy.
Okay. I'd like to follow up on that if possible. I think what was presented today was very compelling to hear the side from people the children still having access potentially to dangerous situations. And I know that we don't have a crystal ball in which we can see all of the cases, but in many times we do see that that could be more traumatizing. And I know there's been a big push to have, I guess, at least a relationship created with both parents, and that is important in many ways, but also preventing any specific further trauma that's created for the child. So I appreciate the foresight there, and would love to maybe have a sit down with you and kind of talk through that if you're open to that. And just to confirm, you are the contact person.
Yes, that's correct. I'm the director of the Domestic Relations Division. However, Charles Goldberg is the public guardian, but I do run the Domestic Relations
Wonderful.
Division.
Well, then hopefully we'll set up some time. Yes. Thank you so much.
Okay. Thank
Chairman,
you.
I'll yield back to you.
Thank you. Commissioner Degnan, Commissioner Miller, then Commissioner Daly.
Thank you. I have some questions about data and statistics. First, at the Chief Judge's office. So, where exactly is the data about domestic violence on the is it on the dashboard already?
No, it's not currently on the dashboard.
Okay, and so
It'll be something that we would create to have a public-facing dashboard.
how long do you think that would take? I know that data is something that we've talked about a lot for a long time, and I think, as I think we had said when the state's attorney was here, it's really helpful for us to identify the gaps, victims to identify who their abuser is, what kind of background do they have before they become more enmeshed with them. There's a lot of different reasons. We don't have to discuss them all now, but when would that data become available? Like, what's the plan?
There is a plan. We've been working with our data analysts in the Chief Judge's office to create the data that would be appropriate to share. As the clerk's office said, there's some data that can't be publicly shared, there's some that can. So we have been working on this topic since the start of the Domestic Violence Committee. I can't give you an answer about a specific timeline, but it's something that we're currently working on. I'd be happy to follow up with you about steps we could take to have some achievable goals.
So then, when you talk about partners, like what are you working internally with, like our Tom Lynch and like our Bureau of Technology, or is it like external partners?
Internal OCJ partners, and then the clerk's office.
Okay, and then, I know that there are state requirements around what is FOIA-able and what is not FOIA-able, but that is not exactly the same as what you can put out generally. Like,
yes.
There is public information that you could choose to disseminate without a FOIA request. Yes. So when you look at what you'd like to share, what are some of the things that you would share and some of the things you wouldn't share, understanding that today you're not going to give us an exhaustive list?
Commissioner, thank you everyone, first of all, for the opportunity to speak here today. And Commissioner Degnan, I wanted to address your earlier question with regards to identifying information about being able to identify individuals that might have a history of domestic violence or anything like that. So I think it's important to distinguish that we're looking at two different sets of data. So one set of data is aggregate data that can help assist us in understanding whether or not we need to, for instance, funnel additional funding into certain of our system partners to help support the fight against domestic violence. There's also identifiable data, which is available to the public in every Cook County courthouse at the public terminals. So when you mentioned, someone who might want to identify somebody that they might be interested in getting into a relationship with and see if they have a history of domestic violence, anyone can walk into a Cook County courthouse and look up that identifying information, see if somebody has domestic battery convictions, see if they have pending orders of protection, as long as those orders of protections have been served.
So let's put a pin in that. So yes, people can come in, but I think facilitating the ease of that is really important. And sometimes people are not going to come downtown or don't have the time in the day to come downtown to go into one of those terminals. So if the information is available electronically, what is the delay for having them be able to do that from their own computers at home?
So there are counties throughout the state that make that information available. I don't know what the delay is. I can't speak to that, but there is a portal that justice partners can get permission to access. So attorneys and other justice partners, so the clerk's portal, which allows access remotely to the same Odyssey or Justice platform.
And that's governed by the Supreme Court remote access policy, which I think was mentioned earlier in the hearing.
But I think that those Supreme Court rules don't disallow it from being, like other counties actually provide this information. I know Cook does not. And I think it's really important that, data is something that is a problem with many governments. Like it's an investment, it takes time. But I think for domestic violence in particular, it is, this is a public process, like we're all paid by the public. And that's public information. So making that publicly available is critical, I think, to allowing you guys to continue the good work. But you're not going to know what the gaps are unless you can aggregate the data, unless you can run reports, unless you figure out what the problems are. And then, like you were saying, then there's information about individual X and what they have done, and like whether or not somebody can look up that information and decide whether or not they want to get into a relationship with them. And I think that we all recognize that going a distance to go find that information isn't going to get us as far as it needs to go. So I guess at the end of the day, what I need to know, and what I would really like to know, is that you guys are committing to make this publicly available. And it would be really helpful, and I know putting you on the spot right now is not the easiest thing for you guys to respond to, but I really like some time frames. Like, we're going to have it in 6 months, we'll have it in 12 months, because then this committee can follow up and say, hey, it's been 12 months, where are we? And without those kind of benchmarks, it kind of leads us into this ambiguous range of, oh, we talked about domestic violence 4 years ago, and now it's coming back up. And I think that, the number of women who have been killed, it's really important. You guys believe it's important. That's why you do the work you do. So can you, maybe not right this minute, but within a week or two, can you get back to our committee and then let us know when you feel like you could have that dashboard up and running?
Yes, absolutely. We can work with you on the timelines.
Okay, thank you.
Thank you.
I had one question for the sheriff and one question for the clerk of the circuit court.
Sheriff and clerk.
Probably the clerk would probably be best for them to come up first.
Clerk.
Hi. Good.
Good. Well, I think the questions that I just had asked the chief judge are very relevant to the work that the clerk of the circuit court does as well. One of the main responsibilities is ensuring that when you get court orders, they're documented, that they're maintained, and that they're publicly available. So whatever kind of systems, the tech systems that the chief judge's office would be able to have and implement would hopefully kind of lend themselves to you guys as well. So are you working in concert with the office of the chief judge to make sure that these orders, the court orders, and whatever kind of case notes are publicly available? Like, where are we on that? I know it's been a long-term plan.
Yes, we work with the chief judge office. In fact, the chief judge governs us. The chief judge orders whether we allow data to go out publicly. And so our data dashboard, the information that they receive, our MIS department is working directly with the OCJ department to make those things available. Now, whether they're going to be available public or what would be available public, that's actually up to the chief judge office working with us and deciding what information will be public.
That's fair, but you know how there's a PACER RACER system where you can get into federal court and figure out, you can look at the complaint, then you can look at all the discovery, you can look at what the final opinion and order is, and you just click on a link and everything is there.
Yes.
When will that be available for civil and criminal?
So
cases?
right now that is available. It's available on our portal.
You have to come to your office, though, to see the portal?
No, so the portal, anybody, justice partner, can request access to that. We give them that access. Actually, it goes to the chief judge. When they grant it, we provide that access to them. And then for every courthouse, the public access terminal that's available. So you can see documents as well as the court orders.
Okay, I think, but much like the questions to the office of the chief judge, you can see that information that can be publicly available in other counties where people can just download it at home from their own computers. Is there a plan to allow just regular citizens to access court records online? It's already online. If somebody can go to a portal, what's the delay? And then having a person just be able to access it online from their own computers.
So currently, you can't see civil cases and documents online other than the order protections and criminal cases.
Why
so,
not order of protections?
Well, order protections
For
because
civil.
They are,
yeah,
Okay.
those
are impounded by statute.
Okay. And then for criminal, what statute, I guess? No, it's okay.
So I don't have the statute.
I have the statute. Okay, just 1 second. So statute 750 ILCS 60//202 section A-5. When a petition of order protection is filed, the petition shall not be public until the petition is served on the respondent.
So once it's served, then for civil, then anybody can see it.
It is open to the public.
In their,
Yes.
not on the portal, like just at home.
I'm sorry, say that again?
So a civil order protection, once it's served by the sheriff's office, is publicly available. Can I go see, if I wanted to look one up right this minute, could I just look it up from my computer?
If you
Not
have
to the
access to the portal.
Right, if you have access to the portal.
Okay, I think.
Yes. But the public access terminal within all offices, yes. You
Okay,
can see it.
will it be available, I guess, eventually to everybody just through their own computers? Is there a plan?
Right, so we take directions from the Office of the Chief Judge. So when they give us that directive to make those, the criminal as well as the order protections public, then that's when we'll be able to
So
release
you
that
on your own volition cannot decide to
No.
allow those civil orders of protection to be available online?
Civil or criminal, right.
But does the statute limit you from having that authority? Does it say that the office of the chief judge has to make that determination?
So it sounds like to me you're asking if the clerk's office is going to develop a system that is very, very similar to that of the federal court, where the federal court has PACER and people use paid subscriptions to go into PACER and look at what they want to look at from that system.
Unpaid. Just
Unpaid.
unpaid.
Okay. So
just for the civil orders of protection, I think in other counties, you are allowed to look up information on civil orders of protection after they've been filed. So that is what my understanding is. So it doesn't seem that the office of the chief judge can say, you should do this or you shouldn't do that, because you're in a separately elected office that makes your own decisions,
Sure.
And you have that authority. Now, if the opinion and order says this opinion and order issued by Judge XYZ is confidential and cannot be put forward, or if there's a standing order from that, then yes, that would designate that that's not allowed to be.
So
it's
I
confidential, but why would you be able to get it like at a portal but not on your own computer?
Because that system has not been created yet.
Will it be created?
So again, we're governed under the Supreme Court rule as well, right? And so they're working on a statewide policy with the Supreme Court. Once that is approved by the Supreme Court, then we're able to do that. But until that, we're governed. We're not allowed to do anything just as the clerk of the circuit court. Again, we're governed by the Office of the Chief Judge as well as the Supreme Court.
Then how do other counties have it available?
Because
they've already been approved for those.
Yeah. I can't answer what's going on with the other counties in Illinois. But we can follow up with you.
Do you guys have an attorney that has some sort of like legal reasoning as to why you can't do it?
Yes, we have a general counsel, yes.
Are they available right now?
No. They're at the office right now. I will have to. Yes.
Yes.
All right, while they do that, let's move on to the next question.
Okay, I just have one more question for the sheriff.
Sheriff's Office.
Okay,
Hi,
thank you. My last question to you is, thank you very much for the presentation you showed earlier. I know that in working with you, you work with a lot of aldermen and alderman staff, and basically anybody who really wants help on DV. I know you've been super helpful to our office, and we have 14 aldermanic wards in my district, and I've heard from many of them that you personally are very available at all times of day. So I just want to get that out there and say thank you very much for your personal work and the work of the sheriff's office.
Thank you.
One thing that was on the presentation was it says DV trainings are offered to staff, and you offer them regularly, you offer them in the fall. So for the people that work in this silo, they're offered, but are they mandatory, or can people choose to take the trainings or choose not to take them?
What we're trying to do is incorporate it and standardize it into our training bureau. Mm-hmm. The focus thus far has been, Jason Hernandez, Executive Director for Intergovernmental Relations, Cook County Sheriff's Office, trying to transition that to our training division so that it becomes part of our standard curriculum. But now the focus has been on staff in court services that are working on the front lines of dealing with the order of protection process. So it's not mandatory as such, but the rollout has been slow because it relies on consultation and the availability of the advocates, which are stretched very thin. But long term, our goal is to get it into the training bureau so that it's part of every deputy assigned to the court's training regimen.
Okay. Do you think, like, within the next year or two, that you would have that be a mandatory training for the folks that are working in this?
That is certainly our goal.
Okay, great. Thank you. Those were all my questions. Thank you. But we'll put that on pause with the office.
Thank you, Commissioner.
Thank you. I had questions for the Chief Judge Office as well as the GAL. So we heard some testimony from some of the advocates who came earlier talking about different judges. What's the judicial review process for some of these cases?
So I think State's Attorney Burke mentioned that the Judicial Inquiry Board is the body that is the independent body that hears complaints about judicial misconduct. If there's attorney misconduct, it would go to the ARDC. So those are the statewide bodies that would hear those.
But I'm talking about so there's nothing through the Chief Judge's office.
So the Chief Judge in the Administrative Authority, I think one of the advocates was speaking about Supreme Court Rule 21. So there is a method for when judges are not fulfilling their duties. There's when there's a significant charge against them that they cannot fulfill their duties. The Supreme Court Rule 21 does give the Chief Judge the ability to take appropriate action. One of the appropriate actions would be referral to the Judicial Inquiry Board.
So an individual has to go through the Supreme Court in order to file a judicial review against a judge?
Well, there's also within a court case, there are methods to contest, a judicial ruling. You can have a motion for reconsideration of the ruling, or you can go through the appellate process.
And how often does that happen for domestic violence cases?
Motions for reconsideration?
Yes.
I don't know the answers to that.
Because we heard so much testimony from people who feel that they were not heard or judges were not working in their best interest.
Yes.
So from the testimony that you heard today, are you willing to take any action based off of the judges that were mentioned here today?
I think the Chief Judge always takes the complaints, always considers the complaints against judges, considers them, and would take that into consideration would evaluate what the complaints are and then take the appropriate action under Supreme Court Rule 21.
So what can we do, I mean, very specifically, because we heard so many today, and I think that especially since many of them have been years in the making as far as what those cases look like, they probably have filed review, and I'm not sure. I'll follow back up and ask your office to provide me with a list of what complaints have been filed, especially in the cases, each one that was mentioned here today, because there's more. This was just all we had time for, and we've been here since 9:30. So if you have information that you can provide us today about what that process looks like, I think that would be helpful.
Yeah, and I just want to also say that the Judicial Inquiry Board process is a confidential process. So the Chief Judge's Office wouldn't necessarily be aware of complaints that are made about judges to the Judicial Inquiry Board unless there was some request for action on our part or was forwarded to the Illinois Courts Commission. So we're not necessarily always aware of complaints that have been made. We do take complaints of judicial misconduct very seriously. We would want to have that information and want to investigate and take the appropriate action.
So,
and I just want to say one more thing. I do think that within a case, there is judicial discretion to make decisions in an individual case. And so I think the Chief Judge would never step in and correct a judicial ruling in a certain case. So that would be something that, again, would be for the appellate process, would be for a motion for reconsideration. But if the judge's behavior under Supreme Court Rule 21 was such that it needed to take administrative action, that would be something that would be within the Chief Judge's administrative authority.
So if we compiled all of the testimony that we just heard from the 10 or 12 people who were here today and provided you with a list of potential what could be considered misconduct, especially since some of the judges were actually making personal attacks and probably inappropriate comments to people who were in court, how would that, without going to an appeal process, I think that's a little absurd, really, to have to go to an appeal process for something that is an ongoing case. So what does that look like from your standpoint?
So again, there could be, a complaint to the Judicial Inquiry Board. We would not be subject to that. We would not know of it. We would not have any access to that information. If there's complaints about judges' behavior or conduct such that it would implicate Supreme Court Rule 21, the Chief Judge would want that information and then to take appropriate action.
And what about the fact that some of the cases that were talked about today really extend, I mean, you're citing now Supreme Court rules. So someone else mentioned a Supreme Court ruling as to the expediency of cases that most of these are way beyond.
So if I could rely on Presiding Judge Canigio to give us some information about that.
Can I use it? Yes, I guess I can. Unfortunately, the nature of domestic relations proceedings is reliant on a variety of other court partners or outside resources that the judiciary doesn't have control over. If we appoint a mental health professional because we believe that there is an issue under a custody evaluation that needs to be completed, we can't tell that evaluator, you must complete this report in 60 days.
Why not?
Well, they're mental health professionals that are not under our jurisdiction. They are a witness, they become court appointed, and we can provide and move them along, but we can't demand that they complete a report in a particular period of time.
But you do demand things on the other side, like people to provide financial documentation by a certain time frame. And
statutorily and under local rules, yes, we do. And those are requirements when someone files a petition for child support or files a petition for modification. The rules require that along with that petition, the financial affidavit be provided. There are DNA tests that in parentage cases, parties come in, and we are reliant on a separate agency to provide that information to us.
Well, let's just stick with the cases we heard today, because we didn't hear anything about DNA.
I'm just talking about those are things that can delay the court process.
But today we heard about delays in court processes that were very specifically due to judicial discretion. and also due to people not being able to pay for certain things that they were asked from, and I'm going to ask about that in a minute, but just, so if we can't, I think there's a disconnect in the judicial response of people being made to have certain cases, certain parts of the case expediently reconciled.
I think and I believe that every judge wants to move the cases through our process as quickly as possible. It is a difficult process, and the Code of Civil Procedure is very layered, and it is difficult for any person to try to understand what their requirements are to move a case through our system. I wish we had more resources available for self-represented litigants in order to help them understand the complex nature of civil litigation, because it is very different than criminal litigation. We don't have that in my division. I wish we did. I wish we had court advocates. I don't have court advocates that I can direct individuals to if there is an order of protection proceeding. We don't have that resource at the Daly Center, nor do we have that in our suburban districts in the Domestic Relations Division. I wish we did. That would be helpful. I can't advise a litigant as to what they should or shouldn't do. But it would be great for us to have that resource to help move them along in a process that is very difficult to understand.
True. So when we're talking about wish lists, so here we are. So these are some of the things that maybe we can put in place and implement. Like we keep talking about, we're in budget negotiations now. If that's a thing that we need more of, then I would like to see that come up next week when we have our budget hearings, when your department presents. So
Commissioner, I would love to be able to give you the wish list. It's extensive.
Well, I want you to give it to us. I do want you to give it to us.
I will definitely do that.
So next I wanted to find out, one of the things we asked in this resolution was to ask, how do the judges appoint the guardian ad litem and the public guardian? Like, what's the procedure used for that?
It's case by case. Every family is unique. And so there's no mandate that the division of the Office of the Public Guardian that has domestic relations attorneys available are always appointed in cases. The Office of the Public Guardian does not provide a GAL, which is different than a child representative. There are cases where the investigation and the ability for someone to be the eyes and ears of the court is absolutely necessary, which is different than taking an advocacy position on behalf of the child and the child's best interest. So it really is very case by case. Each case comes in and it's analyzed on the immediate needs. If something comes in as an emergency, that's going to take precedent over a case where we don't know yet that there's an issue or a conflict or a contest. Customarily, there's going to be some conflict between the parents, either on decision making. There's 4 categories of decision making that parents just can't agree to, or on the amount of time that a child will be spending with a parent. And in those situations, the court needs to look at the culture, the diversity, the language, the special needs of the child, the special needs of the parent, mental health issues, addictions, a variety of different things in making those appointments. And so it is incumbent upon the judiciary to take the time and go through what each family needs. So those are the criteria. There's not a simple checklist that this is what you need to do. It is basically looking at the pleadings and what the litigants are providing to the court as their concerns and their issues. We still are a court of law. I need evidence. I need testimony. I need somebody to have the ability to get that information to me so that I can make that decision.
So that also, there's lots that you just said in that. So the expediency of that also gets delayed because of all these things that you just mentioned. So my first question is, how does a judge decide or assign or decide to assign a guardian ad litem? So it's a case by case, but in general, so I come in and a judge says what?
We don't say anything. You tell us. You tell us that there's a conflict. You file for divorce. Some divorces get filed and people are in agreement and we never see them again. Some divorces come in where the parties have a variety of issues. And I guess I need to say, we are not seeing people at their best. They are in a fight over their children. They're in a fight over their money. They're in a fight with their former best friend, the person that they may have thought they were going to spend the rest of their lives with, and something changes dramatically. We don't know what that change is unless they tell us. We don't know what the problem is unless they tell us. So unless somebody comes in and shows us that there's a controversy or a conflict, we don't know.
Well,
it's
aside from that, I'm not talking about
yeah.
the personal part. I'm really
Okay.
talking about the procedural part.
Procedural part, if someone comes in on an emergency with respect to parenting
Not
time,
an emergency, just a regular case.
regular case, if someone comes in, they filed a petition for dissolution of marriage, they say that they don't believe that they can make decisions on education. The court's going to ask some questions. What's the problem? What school is the child going to? And is this something that the court can work through mediation, through other resources? Is it necessary to appoint a guardian ad litem? Then there's going to be the case that comes in where the allegation on paper is that one parent abused the child, that there is a DCFS report, that there is domestic violence. And those are the cases where the judge is going to stop and look at the response, look at the petition, and make that determination as to what is necessary. Mediation may not be appropriate at that particular time. It may be appropriate to have a GAL appointed to the case so that the GAL can go out and investigate the allegations that each parent is making against the other. And that's why we have the confidential biographies. This is something that was instituted in this last year so that the judges had access and immediate resource as to all the skill set and the background of the GALs to make that proper fit.
So I come in and you're gonna decide who my proper fit is gonna be as a judge.
Yes.
How do you decide which GAL? And then also, I've heard so many variations in the pricing of the different GALs. And then that also delays the court because then if they don't, let's say they can't pay that. And some of these GALs I've heard you say are pro bono, but the majority are not from the cases that I've heard and not from the people who are here today. And so how does the judge then decide, okay, GAL ABCD is your GAL?
So if their first criteria is really going to be who's the best fit? Who's the best fit for this case? The next issue for the court is going to be determined how is that going to be paid for? And that fee structure is under the statute, which simply gives the discretion to the court to make that determination.
So can you read me that statute?
It is under 506, and my notes are back there.
Okay, can somebody read it? I just want it on the record what the statute says.
I'm sorry, Commissioner, I didn't bring my notes up. Glasses on. So the statutory section is 750 ILCS 5/506. This is section B, under fees and costs. The court shall enter an order as appropriate for cost, fees, and disbursements, including a retainer when the attorney, guardian ad litem, or child representative is appointed. And then it goes on to say that any person appointed under this section shall file with the court within 90 days of his or her appointment and every subsequent 90-day period thereafter. During the course of his or her representation, a detailed invoice for services rendered with a copy being sent to each party. The court then shall review the invoice submitted and approve the fees if they are reasonable and necessary. Any order approving the fees shall require payment by either or both parent or any other party or source or from the marital estate or the child's separate estate.
So I think, thank you for reading that. So I think that the issue with that, it doesn't say what the fee actually is. And we've heard variation of fees anywhere from $250 an hour to $700 an hour. So then if someone does not follow through with that guardian ad litem, so you mentioned the 90 days, which is also not being monitored by anyone. I mean, the judge is not monitoring that process, and neither is the courts or whoever else is supposed to be monitoring that 90-day process. So that's a delay. So that's a delay on two fronts. One is the fee, because it's a huge assumption to think that anyone, I don't care who they are, because I'm a Cook County Commissioner, I can't pay $250 an hour for anything. And so, and then if it goes up, and it's not 1 hour's worth of work, it's more than 1 hour worth of work. So then they're getting dinged on not being able to afford that, which delays their case until they've been able to satisfy what the GAL has assigned for them.
So I think, Commissioner, first and foremost, the issue of fees needs to be addressed on the financial resources of the parents. So if the court believes that a GAL is necessary and then finds the right fit, the question then becomes, what are the financial resources of this family? What do each of the parties have with respect to the availability to pay? There are 298s where individuals are receiving state benefits. Those 298s will waive the GAL fees, will not waive the child representative or the attorney for child fees. There's also the opportunity for the judges to contact my office and from the list have a pro bono, have one of the 167 attorneys who's available by their anniversary date of appointment to take a pro bono case. The judge also has the ability to make that call on their very own with that particular attorney and ask, can you take this on a pro bono basis? Can you take this on a reduced fee basis? We don't have statutorily a cap with respect to the fees. We don't have a local rule with respect to the cap of the fees. And I think the reality is, if you need a GAL, if there is an attorney appointed to the case, it's complex. It is going to take a lot of time. It is going to take a lot of attorney resources. It's going to take a lot of attorney availability to meet with family members, the children, look at school records, look at mental health records, interview therapists, interview teachers, interview the list that each parent wants to give you of what is happening in each of their lives that they believe those individuals have important information to tell you. So all of that takes a lot of time and energy away from the general practice of private attorneys. We have no subsidy. It's not as if there's a resource that we have to say, well, if we have a family in the Domestic Relations Division that meets a certain financial criteria, the county has provided us with funds for those court appointed and properly vetted. They should go through the same training, the same process, the same application, the same requirements, but at a reduced rate or a rate that is subsidized to help those litigants.
So that's a huge disconnect. So that's where we're hearing a lot of problems in this specific office, and that it seems that judges are deciding which GAL should be assigned to which case very directly, and that these GALs are not any of the pro bono ones from many of the cases that we've heard from.
And it's very difficult for me because I can't speak to any pending litigation. I have an ethical obligation with respect to any case that is currently pending in my division. So it is a very awkward position for me to be in, to try to address a specific concern by a specific litigant. That case is still ongoing.
So okay, I understand that. So is there a way that you would have data that showed us what cases are still ongoing and how long they've been ongoing that are in the process of a GAL?
That information we'd have to collect from the clerk's office. So by a coding process, we probably would be able to indicate how many of our pending, and I have to discuss this we have pending cases, a case that has been filed.
Right.
Then we have a case that is dormant.
Right.
The judgment is entered and it's just kind of sitting there. And then we have post-decree. So I think what you might be asking for is data that indicates that a GAL has been appointed in a pending case,
Yes.
And how long that GAL has been appointed or how long that case has been pending.
Yes.
And then a GAL that has been appointed in a post-decree proceeding, because they may be appointed in a post-decree proceeding, and how long that case is going on. As I said before, we are the only civil division that pretty much goes on forever.
But is there a way we can, so I had a hearing years ago about something similar for length of stay for detainees at the jail. So similar data was collected, and then we were able to get that data to see what the length of stay was, and then Chief Judge presented us a lot of information about the time period. It seems like we could have something like this. Is that something we can look into to getting that data? Because that is going to, there's so many of the cases that we've heard, we only heard from a handful of them today, but we have many, many other cases that have been in litigation for 5+ years.
I understand that. I think that's working in conjunction with the clerk's office, because there is a coding that goes in.
I'm on the technology committee. I get it.
Okay, great. Thank you, Commissioner. I appreciate that.
Yeah, but
so
coding,
we
do have technology.
Yes.
So we could use
I
it.
think we could work with the clerk's office to gather that information. I would hope that we could also look at other issues, because sometimes it's not just the GAL. It's the nature of the pleadings. It's what is being pled by the party. It is how many times a party is coming in on a particular issue, or what they are or not responding to. So I think a good start is to know when the GALs and how long those cases are taken. But I think we also we need to look holistically at the cases, because they are very dynamic.
Well, sure, yeah. So, but the starting point would just be to have those two pieces of data.
I think that is something I don't have a problem asking our clerk's office, along with the Office of the Chief Judge, to start putting together.
Okay, so we can start look into that, and I think it's in a timely fashion, because everything is being redone with the technology. We've been talking about it for the whole 8 years that I've been here. So I think that adding that button, same thing we did with the length of stay, is something that could be added. That could help your office probably identify these long-standing cases and why they're still going on. Many of them, like you said, are complex, but many of them are still going on just because of payment for the GAL, or the mental health provider has not gotten into the case on a timely fashion. So the statute, and then we could also track the point that you're saying about the statute said something about 90 days. We're beyond that in a lot of these cases.
The 90-day period is the requirement for the GAL to provide to the litigants and to the court their itemized billing statement.
Yes, well, many cases that's not happening.
And I would suggest that where that is not happening, the litigant has an absolute right to say, I haven't received a bill yet. Where is my bill?
And where do they provide that to? Who do they say that to?
To the court, to the judge.
To the judge.
Make that request, file a motion. And this is, again, where it becomes difficult when you're looking for advocacy. Civil litigation is complicated, and it is a motion practice.
Right.
And it's difficult.
Okay, so that helps that part of it. And then the other part of it is that we talked about, that in domestic violence court, this is maybe not just for you, but the fact that the court reporters are not necessarily in every court. And then that's another fee that's supposed to be incumbent upon the people who are coming to court. So if they don't have a court reporter, they're not able to continue on to say what happened in their prior proceedings.
Commissioner, I just want to make clear that at Domestic Violence Court 555, all of our cases are reported.
At domestic violence court.
It's
domestic relation court that does not. Okay.
Right. Exactly. So we have, we record all of our civil cases too. We have a state recording system that is digitized. So we have a digital court reporter
I saw the whole
for our
room.
civil
I
side.
remember.
Yeah.
And so, Commissioner, we don't.
Right.
The statute does not mandate. I wish it did.
Okay, so the statute doesn't mandate that, so that's something that's what we want to come from this hearing on, what statutes we either need to update, eliminate, or change and fix.
On the civil side, we do not have, and we also don't have the resources. We share our court reporters with Law Division, Chancery, Probate, First Municipal. I wish we had more court reporters.
Well,
I wish we
your
had
wish list.
I wish we had a system. I wish we had a system that allowed for competent reporting. We don't have that
So
yet.
could your court mimic what's happening over in the other court?
If I could address that. So for the court reporter issue, we have gone from, in the late 90s, we had 320 court reporters in the Office of Court Reporters. As of now, we have 171.
Right.
And it's not through lack of effort. It's
Yeah.
not because we're not trying to recruit. It's not because we are not doing everything possible we can to have court reporters. It is because we have a statewide shortage, and we are doing the best we can. Because of that shortage, we cover, with live court reporters, mandatory, statutory required hearings. We do have other, as Judge Rice mentioned, the digitized reporting. So that is in specific divisions through a program, a grant with the state. I know our office is working with the county stakeholders on a project with a large price tag to increase technology in all the courtrooms in the county. It would include the ability to present evidence in court, so the technology for that. And it includes a line item for the court reporters. So I know that's something that everyone in this room is working on. I think that would go a long way. We also have the ability to do hybrid recordings. So those are where you would not have it digitized to the room, but there would be a Zoom piece. The Daily Center does not always have the ability to have those courtrooms equipped immediately for that. So we are working on courtroom by courtroom to have as many options as possible when we do not have a live court reporter in person. There's also the issue of transcripts when transcripts are ordered. So those are something, again, that court reporters, we have on staff who can create those transcripts. There are fees associated with that. Some of them can be waived, but some of them can't. So I believe we provided a slide deck to the commissioners with that information, but I'd be happy to follow up with more detail with your office.
Yeah, so I just think that since we are really, from the state's attorney's report of the increase in domestic violence cases in a short period of time, I hope that we could look at this as kind of like a state of emergency that we're in right now. And that not only just from the pending cases of the people who are able to even still testify, but unfortunately, people have been murdered. Why this has been delayed or that we're still working through some of these issues. So if we could make this the top priority for our cases because of the increase, we have data to show us that now we need more. We've been talking about it for several years now, and now we even need more, that this is what we're saying is this is the time to make that plea and make that case. And if there's a state mandate that we need to go to Springfield and advocate for, I think we'd have busloads of people willing to help us do that. But so if you can help us make that happen, and I think that what we can do from our standpoint is make whatever happen next week when we're talking about preliminary budget adjustments and where things need to be. I always say it's not that there's no budget, it's how the budget is allocated. So how can we allocate other funding towards this really crucial issue that's happening right now in front of our faces? So thank you for that part. Thank you for that explanation. And we'll just look forward to, I would like to see something. I'll have my office follow up with your office about how these things need to be identified, and so it's on a piece of paper, and also the statutes that we need to have language changed on and what that looks like and who can advocate for that. I know we have lobbyists here at the county, so maybe they can put that on their agenda item.
Thank you, Commissioner. I look forward to getting that.
Thank you. Commissioner, you done? Daly.
Thank you, Mr. Chairman. And again, let me thank all those who participated today. Needless to say, there is a disconnect. And this disconnect has to be coordinated. As I've heard and listened, there's a number of requests within the preliminary budgets that will be coming next week. Those budgets hopefully contain some of the requests that have been submitted today, or should be submitted today. But it's not about just more money, because this board will have to vote for additional revenue to support additional people. But it's also as how we coordinate this better together. And you go into the hospital, and you had previous surgery at, say, at Elmhurst Hospital. That record is connected into Northwestern or any other hospital. That, to me, and I'm all for these changes, but before we get to the step B, we have to have some coordination going on. And that, I think, is important as we go to the preliminary budget and into the final budget. But Judge Rice, in your information, you had indicated, I think that for a person to file a complaint, it's 36 pages.
36 pages long.
Now, who came up with that formula or that?
I would love to know the answer to that, Commissioner Daly. No, there is a committee through the AOIC, the Administrative Office of the Illinois Courts. It's a forms committee. And they put forth all the forms that are used, uniform forms that are used in Cook County and all counties in the state. Mm-hmm. And we asked that they simplify the language on some of the forms because there was a lot of legalese and things that people didn't understand. But in simplifying some of that language, that made some of these forms longer. Also, with the number of new laws that we have, we're asking for more information, such as Karina's Law. We're asking for more demographic information about the offender. And so if you have children together, we're asking about information, who is the parent that does most of the parenting time with the child. So all of these things, that information that we have to have in these cases are on these forms, and they're lengthy. And so we need either our legal community or advocacy community to step up a bit more, to be more present with us, to help people to do this, because the vast majority of the people that come to us are self-represented.
Well, that's what, when you stated that, I mean, an individual comes in, he or she, how do they complete this form? I mean, and I'm sure, hopefully, there's people.
Yeah, that's why one of the recommendations was that we hired legal litigant services associates. So
correct.
We have 3 of those right now. We can use more of those to help people.
And this is all additional dollars. And I just want to follow up on, can an individual file remotely?
Yes. Individuals can file remotely through the clerk's office. They can file remotely at night. Our after-hours program, we have a partnership with the network and CAWC. The individual, if they call in, if they can't get through the document on their own, they go through through the network to CAWC, and we have advocates that help them to fill out the form remotely.
And then the final question would be, when an individual calls 911, the police come out, he or she indicates that they have an order of protection. Can the police issue a warrant check to see if there's a current order?
Yeah, there's a system called LEADS, a law enforcement database, and all sworn police officers have access to LEADS. So even if in our after-hours program or during the day, the clerk is batching all those orders of protection and sending them with a transmittal into LEADS and their input into LEADS.
So when the police respond, they could check that and then issue it there.
Right.
Correct.
We have had some cases, as you know, Commissioner, where the timing of that was an issue. The case has gone into LEADS later at a later hour, and the police responding early, they can't see that there's been an order issued. So
thank you very much. Thank you.
Yeah, thank you. Judge, when I'm not in committee meetings in the chamber, I serve on the IJC, Illinois Judicial Conference, and I'd love a chance for us just to talk offline, and you give me a list of things that I can certainly try to get us to address, in that space. Would that make sense?
That makes a lot of sense because, as you heard about the prices of attorneys today, people can't afford attorneys for these cases, and we need attorneys to do pro bono work, to volunteer with us, to come and help us get some of these people assistance they need.
Get your list ready. Thank you.
Okay.
Commissioner Degnan.
So thank you, James Chandler, for coming right over and answering the question that I think that you had heard about when the clerk of the circuit court will have a dashboard up and running to produce, I guess, or publish information related to these types of protective orders.
For the record, James Chandler, General Counsel, the clerk of the Circuit Court of Cook County. To answer your question, Commissioner, we're working towards that end. Our main goal is access, not only access to data of what everybody's interested in for types and numbers of cases, but also access to the actual documents and events that took place in each case. But right now, we're having this battle between balancing an individual's right to privacy versus the public's ultimate right to know. And those are competing interests that we have. Obviously, if there's a compelling interest involving someone's safety or health, we err on that side. But right now, we're working towards that end for complete access, not only for litigants, not only for law enforcement agencies, but also pro se litigants and the public at large.
Or the documents that are in the bucket where you can produce them and that there is not an address or a social security number or something like that that you're prohibited from producing. When do you think that those documents might be available publicly to folks who would like to see them? I recognize that including a new technical dashboard takes some time. I know that we have subscription services and that you can look for new systems and that tech is evolving. But at the end of the day, it's in your interest as the clerk of the circuit court, our interest as a board, and the public's interest to see documents that are publicly available. So when do you think that work would be done to kind of get us all where we want to be?
Without committing to a certain timeline, I can tell you that the current portal is being sunsetted by Tyler Technologies at the end of the year for our county. So, but there's other products that we're exploring to that end to get to where you and all the commissioners want to go. And just to be clear, I think there's two different transparencies that you're looking at: data, just numbers of cases filed and that sort of thing, and then actual event and case data. And those are going to be two different things. When we talk about the dashboard, that's the data dashboard with different information, and we're working towards adding to that every day. And every day we work towards providing more access on the court file side as well. So in the process of trying to get a new product, which we'll obviously need money for, but in that process to the end that you're asking for is what we're working towards too.
Okay, so I think that this might be a good topic to talk about next week during mid-year budget hearings, because if that new dashboard needs to be implemented in or by January or February for continuity's purposes, and if it's a subscription service where if somebody would like to see that information, they have to pay for it, then the question becomes, does the county pay for that data and information as a public service because it's public information? And is that a part of your budget for FY26? Or is that a service that the public has to pay for per page in order to see it on their own computers? Because I think the compelling interest is that in cases where there is harm to the person or their family, that should be in a different bucket rather than somebody just looking at something that does not cause harm or death to them. So there might be some ability for the clerk of the circuit court to differentiate between those types if it becomes a money issue. I'm not saying that you should or you shouldn't. I'm just saying that there's a spectrum of opportunity there. So thank you very much for coming over here. You've answered my questions.
Thank you, Commissioner.
Frank Aguilar.
Thank you, Chairman. This is for the public defender.
Thank you. I think the issue earlier was that the statement was that there was a statute that limited this information from being provided, and that you had to have some kind of continuity between the chief judge and the clerk's office. So are you saying that that's not the case?
No, it is. And I think the the question might have been taken in a different context of when an order of protection has been issued but not served. That's statutorily we cannot make that public.
No,
then,
so that's the issue.
Yes.
Yes. So we read the statute, and maybe you should read it again so that we can get clarity on what that language really says. It doesn't say you can't do that.
It's the way I read it. It said until it's served.
Okay, until it's served,
yes.
and then yes.
and then it's allowed to be public.
Okay. Yes. And so now we're talking about getting the information public facing once it's been served, creating this dashboard that doesn't exist yet, that could easily exist because we've been talking about how dashboards can be created during our technology long time meetings for many years. So if that's something else that we can, whoever your data person is, can let Tyler know that maybe they should just do that for free since we've spent billions of dollars. That seems like an easy fix there, but more importantly, seems like something that could be done in a short term. And then I just want to also understand, since other counties, Will County has this, so they're smaller than us. So how can we make sure that we are at least doing the bare minimum, because this is the bare minimum, to provide this information in a timely manner?
Commissioner, I'm not familiar with Will County, but we will do our due diligence on Will County and other counties like it. And to the extent it can be instructional and demonstrative to get us off the ground, we will certainly consider that.
Okay, but yeah, I would love for you to have that meeting with whoever it is in other counties that have this. I think even LA County, that's the largest county in the country, has something like this. So it's not that it's not being done. It's just not being done here.
Understood.
Okay, thank you.
Thank you, Commissioner.
Aguilar, right before you do that, I want Commissioner Lowry to
Thank you,
make
Chair.
an announcement.
Thank you. Earlier I recessed the meeting of the Cook County Health and Hospitals Committee pending the call of the chair. I will be calling that committee into session tomorrow on Wednesday at 11:40 a.m. We have 7 presentations, so we're not going to cover that today. We'll do it tomorrow, commencing at 11:40 a.m. We're going to recess until tomorrow morning, 11:40 a.m., Health and Hospitals.
Thank you, Chairman. We'll send that notice out.
Commissioner Frank Aguilar, then Maggie Trevor, Bridget Gaynor, and Scott Britton.
Thank you, Chairman. This is regarding the public defender. Last year, we had some discussions about the situation going on with our immigrant community. It's being terrorized, and when I say terrorized, that's what's going on with that right now. Additional attorneys to have a due process. They're taxpayers. They do have a right to due process. What's the status on that?
I'm going to make a point of order. I believe that's beyond the scope of this hearing. That relates to immigrant rights. This is domestic violence. I don't think we should be addressing that.
Okay. Pardon?
Commissioner, do you want to refrain from that question, or you want to continue?
No, refrain. Just refrain. I'll refrain from it.
Thank you. Any other questions, Commissioner?
Well, it's a budget question. What's the status on it in terms of attorneys? What's the status on additional?
Okay. Thank you, Commissioner. And first off, we're very appreciative of your interest. Our office continues to have a strong and vibrant immigration representation division. I know that our office leadership is diligently preparing for the budget hearing, and I'd be happy to make sure we get you that information to talk further about the details of that.
Okay. All right. Thank you. That's it. I appreciate it.
All right. Commissioner Maggie Trevor.
Thank you, Chair. Most of my questions have been asked already, but by Commissioner Miller, as a matter of fact. And I would like to follow up on the GAL, the child representative and the attorney for the child question. Historically, one of the biggest barriers to getting out of abusive relationships has been economic. And, what I heard from the testimony of the people who spoke at the beginning of this hearing was some sort of frightening financial scenarios. And I realized that for some of these categories that you do provide you assess the family's financial condition. In some cases, this is pro bono, but in other cases, it's not. And anybody who's either applied for college financial aid or done this for their children knows full well that other people's assessments of your financial ability to pay sometimes are not necessarily the same as yours. And what I worry about with this is that when presented with these costs, that people will choose to stay in abusive relationships. And I'm wondering whether or not, when presented with this scenario of having this person, the GAL appointed, or any of these other categories, whether or not there's an off-ramp for people in this process. And if so, what percentage of them take that off-ramp?
I don't know that I can answer the question with respect to the off-ramp. What I can tell you is that judges are trained to look at the needs of the family and the financial resources that are available. I know that each case, as I said, is very different and very unique. And I do agree with you that each judge is going to assess a family differently based on their discretion. In the civil division, the Illinois Marriage and Dissolution of Marriage Act provides very broad discretion to the judiciary. So there isn't a one-size-fits-all. And I think it would be difficult to even try to implement something like that, given the complexity of the cases. But I hear what you're saying with respect to having a more sensitive view of the financial needs or the financial resources of families and the needs that the family has in the appointment of qualified. And that's where I want to make sure we want qualified, well-trained, well-educated, diverse GALs and child representatives. Everything in the civil division is private. We don't have state's attorneys dealing with the issues in our cases, with the exception of 4D child support. We don't have public defenders. Everything in our division is private and civil. So we have to, it's a balance between making sure that there's quality and well-trained and well-educated GALs, but also making sure that the judiciary is cognizant. And we don't know the financial resources of parties until we ask those questions. And we don't know about 298s and whether they're receiving benefits. We don't know what they have until they provide that information to us. And I do know that it is difficult, and we don't want people. I cannot imagine a world where a judge wants an individual to stay in an abusive relationship.
And I understand that, but I think the reality of or not necessarily, because I don't know, but whether or not there is whether or not when they're faced with this point in the process, whether or not they have the option to essentially withdraw, and if so, how often that happens. I guess I'm just
the litigant or the GAL.
The litigants.
The litigants always have an opportunity to voluntarily dismiss their case or withdraw their issues from the court.
And I would love to know if there's any statistics on at what point in the process that might happen for how many of them do, and at that point in the process, when faced with these costs, simply say, "I'll stay in this relationship," rather than proceed down this road.
That information I don't have, and I would really try to think about what the structure or the not dynamic, but what the programming would look like to try to find that information.
Yeah. Okay. That's the only question I've got. Thank you.
Thank you.
Commissioner Gaynor.
I think that while I appreciate the role of all the people who are here, judges and staff, I know that next week we are here, at which point we'll have the actual principals, the chief judge, the clerk, and others, not to diminish, but you guys have been incredibly patient. If no one else has questions, I'm going to move to my meetings that have to be good. Are we good to go? What I was asking is, I didn't know you had a question, but the thing is, in a week, we're going to be before all of the principals again, at which point we're discussing the actual budget, the resources, and the decision makers are going to be here, appreciating the obviously important role of staff. So I was going to kind of allow us to maybe get organized about a few things for next week and then plan accordingly.
Really quickly, when you come back next week, can you bring the metrics? I would be really interested in knowing, of those 172 GALs, how many of them are actually receiving cases? Yeah. How many have what caseloads, like what level of cases do they have, and for how long have they held on to those cases? So I can get that sent over so that you can have that prepared in some type of written form for next week.
That might be a bit difficult to do in a week. We have 167 GALs on the list. We could possibly pull that information with help from the clerk's office by running their attorney code.
Correct.
And then determining, but now you're also talking about decades worth of information.
No, we can do 2 years. I'm just interested in how many what the caseload is now, because based on what I'm hearing, I'm wondering if it's kind of like a hustle. You know, it's like I don't want to believe that, but I'll know more when I see the metrics.
I would say
exactly.
We're talking about 167 attorneys who've gone through a process, who have either are working in firms or have their own private practice, and there is not a subsidy or an underwriting for their fees for any of the cases. Okay. So, Commissioner, are you asking just for a 24-month period of time?
That would be a start, yes.
Because I think, some of these individuals may have been on this list for a good number of years, and it would be almost impossible. But if you're saying
only 167.
167, you're talking about asking the clerk's office to pull 167 attorney codes and then 2 years worth of information for the cases that they have been appointed to. Is that what you're asking?
Yes.
I want to make sure that I get the information correctly.
Correct.
Okay.
And that would be a start.
Okay.
All right. To wrap up, Commissioner Stamps, Commissioner Morris.
Thank you, because it goes to that. So while we're digging on the GAL, I want to know, on average, how often is a GAL requested for cases that come, that the judge says, oh, at this point now you all need a GAL? Also, out of the 167, can you provide data on which ones are being assigned most often and by which judges?
Commissioner, I'm not sure. I'll work with the clerk's office to see what we can find, because we will know by the attorney code. We will know what cases they've been assigned to. By the case number, we will know what calendar it sits on of the 45 judges that we have in the division.
Again, I have every confidence in your ability to furnish this information.
And you need this for next week. And trust me, I can't, just so that the commission knows, I can't pull that information on my own. I have to make the request to the clerk's office, and they are here, and they've just nodded, and we will have a conversation tomorrow to get the process started.
Thank you so much.
You're welcome.
Commissioner Sean Morrison to close.
I just want to thank all the participants who came today. Sometimes when you have a committee meeting that devolves for 7.5 hours, the level of decorum and professional respect also declines. To the 167 court-appointed GALs that were just castigated, that's not the view of this board. And we thank you for the work that you do. We thank the court systems for the work they do. Of course, we also acknowledge that there are cases in everything in life where there might be There might be randomized things where things have not gone right. We should always look to fix that and make those things better. But for the most part, please, I would like that for our civil courts to understand that this is not a castigation or judgment made against them as a whole, but a serious attempt to look at some very finite areas where improvement can be made. Chairman, thank you for the time.
I appreciate that. Thank you. All right.
Are we ready to call these meetings?
There are no other questions.
There's no vote.
Chairman, green button, try it again. Just once. Try it again, just once. Control room, can you come out and help Commissioner Moore, Chairman Moore, with his gooseneck mic? And Chairman, because you had remote participants, I'm not sure if they're still connected. Let me do that first. Commissioner Marita, are you connected? Commissioner Marita, are you connected? Commissioner Scott, are you connected?
Yes, I am.
Thank you, ma'am. So,
Marita
Chairman,
present.
we do need to do a roll call because they are connected.
Okay, on the item 251695, Commissioner Miller will move to approve this item, a proposed resolution calling for a hearing of the Criminal Justice Committee to receive an update from the public safety county stakeholders on the implementation safeguards for the protection of gender-based violence survivors and domestic relation mediations and child representation. Seconded by Commissioner Trevor. Seeing no further...
Commissioner Naya is the second.
Commissioner Naya is the second.
Thank you.
Seeing no further discussion, all those in favor?
Roll call, please.
Roll call.
Thank you. Roll call.
Thank you.
Commissioner Aguilar, your vote, sir?
Aye.
Commissioner Aguilar is aye. Commissioner Naya? Commissioner Naya is aye. Commissioner Britton? Commissioner Daly?
Aye, and as a reminder, next week is preliminary, so we will begin this discussion, but once the budget is presented, we will have to have a lengthy discussion on how we coordinate all this together and where the revenue will be.
Thank you, sir. Commissioner Daly's vote is aye. Commissioner Degnan? Aye. Commissioner Degnan is aye. Commissioner Gaynor?
Aye.
Commissioner Gaynor is aye. Commissioner Laurie?
Laurie's aye.
Commissioner Laurie is aye. Commissioner McCaskill? McCaskill is aye. Commissioner Miller?
Miller, aye.
Commissioner Miller is aye. Commissioner Marita? Commissioner Marita, your vote, ma'am?
Aye.
Commissioner Marita
Marita,
is
aye.
aye. Thank you. Commissioner Kevin Morrison is absent. Commissioner Sean Morrison?
Sean Morrison, aye.
Commissioner Sean Morrison is aye. Commissioner Scott?
Aye.
Commissioner Scott is aye.
Yeah.
Commissioner Stamps? Commissioner Stamps is aye. Commissioner Trevor?
Trevor, aye.
Commissioner Trevor is aye. Commissioner Vasquez?
Aye.
Commissioner Vasquez is aye. Commissioner Britton? Chairman, your vote? Aye. Chairman's vote is aye. Commissioner Britton? I will mark as absent. Chairman, you have 15 ayes and 2 absent.
Seeing no further discussion, the ayes have it. We are adjourned. Move to adjourn. Moved by Commissioner
Madam
Naya.
Chair, I'd like to reconvene the Business and Economic Development Committee meeting.
What's the motion for adjourn? Commissioner Naya, second by?
Commissioners Sean Morrison.
Thank you. Our next committee is BED. Can we have your attention, please? Commissioner Gaynor has the floor.
Thank you. Are there any registered public speakers?
You do have one speaker, George Blakemore.
Mr. Blakemore, are you present to speak before the committee?
George Blakemore. George Blakemore, you have 3 minutes to address the body, sir.
Mr. George Blakemore, it seems like I'm going to be speaking to empty seats and commissioners here. So it was very interesting to see this saga that goes on here. I couldn't believe it. And right now you want me to continue to speak and all the noise is going on. You got rules for them and rules for public comments. Now why should I speak